because the High Court has refused, as it were, the application filed by lawyer Atachia. He said that he needed to be out of the country, and so the judgment was supposed to have been the 20th of this month, together with the consideration of his application. But of course, the High Court has refused that, and the judge said adjournments are at the convenience of the court and not based on the personal indications of lawyers. It says court also dismissed the application for deferment and referral to the Supreme Court, and the judgment is currently proceeding, as we've been told.
Well, so far, man on the ground, Lord Iduasare is in the chamber, and then also taking note as the judgment is ongoing. We'll have Joseph Akablay, Esquire, who then will also help us give us the facts of the case as it is, and then also subsequently the charges that have been preferred against Bernard Samreboi, aka Chairman Wontumi, and then his company, Akunta Mining Company Limited, who are the defendant in the case as well, and subsequently Kwame Entry, who we all know is at large. And so subsequently you also have the various statements of offenses when it comes to what is on the charge sheet based on the offenses that the Republic, the Attorney General, has preferred on the accused person. And it includes assignments of mineral rights without approval, and subsequently also goes on to also enumerate a number of the offenses, particularly when it comes to facilitating the usage of unlicensed mining operations and rights, contrary to sections of the Minerals and Mining Act. And then we'll bring you up to speed with what also has been done by the way the case has so far traveled, and leading to the application by his lawyer for that judgment to be deferred. And we know that that has been dismissed by the court, and subsequently we have the judgment being read by the court to get to the current end of the matter, so to speak. And so we'll apprise you of the latest. And Joseph also, when he's ready, will give her up to speed on what so far has been done and how the case has traveled, but more importantly, what the charges are and where we are currently. Well, if Joseph is ready, we would want to get the latest as
Indeed.
it is. We know that Chairman Samreboi was an accused person in his company, well known within the public discourse of the Republic of Ghana, also because he is chair for the opposition MPP for the Ashanti region, and then making a bid for the national chairmanship position of the MPP. And so he's no mean a figure. Joseph, what can you tell us?
Very interesting developments from the court this morning, and we begin our build-up as we wait the judgment of the court. The judgment is being read. A lot of the times the court would have to do an introduction, analysis. The judge will refer to the in terms of the charges that have been filed against him. The judge will now proceed to now assess the case of the prosecution, the case of the accused persons. In this case, there's Chairman Wontumi as the first accused person. There's a second accused person, one Kwame Entry, who has been described in court processes as being at large, which basically is a nice way of saying that the investigators and the police, for that matter, cannot find him. And so the case against him did not proceed in respect of that particular matter. But the court proceeded against Chairman Wontumi as the first accused person, with Akunta Mining being the third accused person in this particular matter. And so the judge will do the analysis of the charges against Chairman Wontumi and also the charges against Akunta Mining as well. Then they will present the case of the prosecution, the case of the accused person, do the analysis of the evidence that has been adduced so far. Then the court will now come to its own findings and conclusions on the basis of the evidence that has been presented so far. And once the court is done with all of that, it will now come to its conclusions on what the judgment should be. And a lot of the times, for the viewers and everyone, the most important question we all ask is he guilty or is not guilty, is the question that we tend to ask. And the court will answer that question definitively. In the event the court comes to the conclusion that he's not guilty, then it means that he's acquitted and discharged, which would basically mean he walks out of the courtroom a free man. He goes about his activities. The case that has been brought against cannot be brought against him in the same form, or if it relates to facts that arise out of this particular matter, it cannot be brought against him once again. And so that is one possible conclusion. Another possible conclusion will be in the event that he is found guilty. If he is found guilty, the judge would announce that as well at the tail end of the judgment, and now will ask the lawyers to address the court on the sentence question, because once you've been found guilty, the court would have to pronounce sentence, and that's when the lawyers have to address the court. It's an important clarification that we need to obtain, because you know that Samuel Atachian, who represents Chairman Wontumi at this point in time, has indicated that he's not in the jurisdiction now. And so we need to answer the question of whether there's any lawyer from the chambers that is present in court. If no lawyer showed up at all, and from what we heard, the letter that was written, the court rejected it and the court proceeded to deliver its judgment. If there's no lawyer present, it will mean that Chairman Wontumi himself may have to address the court on the sentencing question. For those of you who have been in courtroom, that is the point where the lawyer will tell the court that you basically speak to the court about facts that inure to your client's benefit. So you will talk about the fact that maybe he's a first-time offender, he's a responsible person, he's an upright citizen, he's known, he has dependents, all those facts that basically you are urging on the court to more or less let the court be lenient in imposing a sentence, because a lot of the times the sentencing range would have a minimum. In case that it doesn't have a minimum, it may have a maximum, or in a situation where there's no maximum, it's just at large. And so it's in your interest that you now talk about some of the things that are to the benefit of your client that should weigh in on the judge's mind in order not to impose the hard sentence. Sometimes you can make various commitments in those addresses as well, and once you do all of that, the judge would then impose a sentence. But all this is on the assumption that if he's found guilty. But on the other hand, like I stated earlier, if he's not guilty, then it simply ends, he's acquitted and he's discharged. And so those are what we are expecting to play out in some few minutes as the judgment is ongoing at this point in time, Roland.
And usually within the court setting, I mean, given a judgment, particularly on a case of such nature, will not necessarily be involving a two-pager, so to speak. Just take us through, particularly when we know that the lawyer for Chairman Wontumi, that's Atachian, had put in this application to enable him travel, or because it's out of the jurisdiction, the judgment and the way it has to be given today to be put on hold until there's any resumption. Could the court have taken into consideration that, and what usually is the other precedent that is around?
In fact, the substantive points which any lawyer would agree with is the fact that the court regulates its procedure. In fact, there are multiple Supreme Court decisions and even decisions from the other courts, the Court of Appeal, High Court, to the effect that it's the court that regulates its procedure and its proceedings. So it's the court that fixes the dates. So there are instances where if you're a lawyer and you can't show up, and it is with that understanding, that is how come they wrote to the court to request for the adjournment, because they know that the court ultimately has that decision to make. Yeah. And anyone who has seen the letter that Samuel Atachian wrote, he concluded by saying that it is for the consideration of the court. So the first fact we need to all accept is that the court decides how it regulates its proceedings and procedure. That's the first point. The second point has to be that once a request is made, the court would have to exercise a discretion, and the court exercises the discretion based on the facts available to it. Now, the judge has taken the view that the facts available to it available to the court in terms of how the case has proceeded, the request for adjournment at this point in time, and the court has taken the view that, well, it wants to proceed. In fact, there have been instances where courts have decided to regulate its procedure in a certain manner, which has ended up in the Court of Appeal. I can quickly remind you all of the Republic versus James Jachi-Quayson. You remember that the High Court had taken a decision that it was going to hold a trial on a day-to-day basis. When the matter went to the Court of Appeal, it was one of the issues that lawyers for Mr. Quayson had raised at the Court of Appeal about the fact that they felt that had inconvenienced their client and suggested that it meant the court was in a hurry to deal with the matter. And then the Court of Appeal in clear terms said that the point being made is that the judge who is presiding over the court regulates the processes, and there's a duty on all parties actually to ensure that a matter is dealt with expeditiously. And so that was the view that the Court of Appeal took in that particular instance. And so if you disagree with how the court assigns that discretion and you decide to challenge it. And that is when you would have to demonstrate that the judge was actuated by malice, the judge acted in an arbitrary and capricious manner, and that given the same facts, a fair-minded person who is seized with it will decide that they would rather adjourn rather than proceed. And one could even say that, well, Mr. Atachian had said that he was going to be available on Wednesday. And so why not a short adjournment perhaps for the court to come back and hear the motion on Wednesday? All these are matters that you could raise. But, I mean, what we have to work with now is that the judge has taken the view that this is a matter that she does not intend to exercise the discretion to grant the adjournment as has been requested. Okay. And the factual context which we are working and operating within is the fact that judgment should have been given on the 4th of July. That was the initial date, actually. And it was some weeks. You remember that the 27th June, in the previous month, that was when the initial lawyers were supposed to file their written address. It's basically a summary of the evidence that has been led at trial. And so they are supposed to file that, do an analysis of the evidence, show how Chairman Wontumi is guilty or how he's not guilty, depending on if you are the prosecution or you're on the side of the accused person. And so that was what they were supposed to do by the 27th of June for the judgment to be delivered on the 4th of July. Then we all know that Andy Appiah Kubi, who represents Chairman Wontumi at the time, informed the court that he was stepping away from the case. And so when Atachian came in, he now asked for a bit of an extension to enable him to be abreast with the matters surrounding the case. In fact, he wrote to the court, told the court that he wants to be given the record of proceedings, and he had not obtained it. And so he asked that the court adjourn proceedings and push the date further to enable him get that. The court granted all of that. He was given some more time to do so. Then the judgment was now fixed for 20th of July. And we know that he's filed that written address. But in filing it, he now raised some issues that the nature of the charges against Chairman Wontumi, some of them are matters that require the interpretation of the Supreme Court. And just by way of a bit of information, the Supreme Court ultimately has that power to do the interpretation, Roland. I think we can cross over now, Roland, to the Supreme Court. Yeah, I was supposed to go
to Sixtus Don Ulo, also a legal practitioner and then a broadcaster as well, right here also with Media General, because the other considered matters that usually we take cognizance of when we undertake such coverage. And you have been through many, many years, Joseph Akablay. But there's a question I wanted to ask about whether in making considerations by the court, do they take judicial notice of events outside the court in making those considerations in such judgments in the first place? But first, let me establish whether Sixtus Don Ulo is ready. Good morning to you, Sixtus. What's the atmosphere at the court currently?
Well, Roland, as we speak now, there's a high turnout, rather, of media personalities. You would reckon that this is a particular case that has attracted widespread interest. A lot of media people have taken interest in this matter with the intention that they would get first-hand information so they in turn can broadcast to their various audiences, whether print, electronic, whether new media. We have media practitioners of all definitions and descriptions here. But the courtroom itself, I can tell you, Roland, is packed. It's overflowing. It's impossible for anyone, as we speak now, to step foot into the courtroom. I took a quick scan of the courtroom. This is happening in the Criminal Court 4 of the High Court. And if you get in there right now, it is not possible for you to even step foot in there. We have some court security personnel posted outside the gates of the courtroom who are managing order inside of the courtroom and on the corridors of the court. For those who are familiar with the court complex, the High Court complex as we call it, is a 5-story building, and this is happening on the 3rd floor. That is where you would find a particular courtroom that is hearing this particular matter. And on that whole floor, you have people, whether they are interested, people who are interested in the outcome, relatives of Chairman Wontumi, party people, you have lawyers who have finished their cases and also just strolled in to listen to the judgment and all of that. So you have people of all walks of life, if I can put it that way, who are there just to hear or get first-hand information as to what is happening. Unlike a lot of the other cases that we have seen, even in this particular case, at one point in time we saw heavy military police presence outside of the court's house itself. Today it's not like that. I see a few policemen posted who are at the gates, who are just very relaxed and watching that there's law and order. You don't have so many people. You don't have the party people that you usually would find around. You don't have the relatives, friends, and sympathizers, so-called, that you would usually find around. You don't have any of that. The atmosphere is serene, rather dominated. I almost said curiously, but on a second thought, it's not curious. Dominated by media persons who are here. So for the first time in my coverage of such cases, I'm seeing that the public has stayed clear of the court premises and maybe glued to TV3 and listening to 3FM, waiting for us to bring them the details. For now, it's peaceful, it's serene, and all we are waiting to hear is the judgment of the court coming out of the criminal division of the High Court.
Okay, why has this evoked a lot of feelings and sentiments within the public space? I mean, the case in itself.
Well, you know, yes, earlier in your discussion, you and Joseph alluded to this. You would realize that the person of Chairman Wontumi is a very controversial regional chairman of the NPP, then governing NPP, now biggest opposition party. He's a very controversial businessman. Aside from being a controversial politician, he's a controversial businessman. Don't forget, he's also openly declared that he is eyeing the national chairmanship of the NPP, which has significant implications for both his personal political aspirations and for the future and interest of the NPP as a party. You would also realize that in the lead up to the 2024 elections, Chairman Wontumi is one person who generated a lot of controversy owing to his utterances about the NDC, his utterances about then flag bearer John Dramani Mahama, his utterances about policies of the Akufo-Addo administration at the time, his firm conviction at the time that there was no way that the NPP was going to lose that election. So the man succeeded in, putting himself out there as a national figure. And so in all of the conversations, all of the spheres that I have mentioned, whether politically, business-wise, social commentary-wise, political commentary-wise, he has endeared to himself people who either, like him, who don't like him, who like his style of politics and business, who don't like his style of politics and business. And all of these people want to know what next for Chairman Wontumi. So this is one of the reasons you would see that there's such a high level of public interest. The second reason we can give, Roland, is that the trial itself sparked and generated so much public interest and controversy. The lawyer who handled this, Andy Appiah-Kubi, himself is a man of no mean controversy. He speaks with such firm convictions, he speaks his mind, he is principled, whether as a member of parliament, he doesn't mince his words, whether as a member of the NPP, he doesn't mince his words, whether as a lawyer, he doesn't mince his words. So Andy Appiah-Kubi himself brought a lot of public attention and interest to this particular case. And now we move to the lawyer that took over from him, the Honorable Atachia, another controversial person, whether politically or legally. He is one lawyer who doesn't also mince his words. He says it as he believes it to be. And look at the changeover, which is a discussion that you and Joseph were having. In this changeover, in other cases, you would expect the lawyer to just write notifying the court that I have been appointed as counsel in this particular matter with this suit number. The court looks at the document and the new appointed lawyer takes over as counsel in the matter. This one didn't go straightforward like that. In this particular case, you had a lawyer. In fact, Andy Apiakubi himself notified the court. The court said, no, you are going nowhere. You are standing with us till judgment is delivered. The accused person himself, Chairman Wontumi, he also wrote a public statement saying that, look, I have parted ways with my lawyer, and this is my new lawyer in this matter. The man, when he took over, that is the Honorable Atacha, he took over, and the very first thing he did was to stir controversy. He wrote to the court, telling the court that, look, I have just been appointed a lawyer in this matter. I would need time. I know that you have closed the case, the state has closed, we have closed, you are writing our judgment. Indeed, and in fact, you may have even already written your judgment. But please, give me some time. I need to review all the processes. This was his statement to the court. I need to review all the processes to be sure that my client is on a right footing to a fair hearing, that justice will be dealt to my client, and that however this case pans out, I will be firmly convinced that indeed the court has been fair and just and firm with my client. So that dynamic in itself generated a lot of public interest. And that is another area that you can say that, yes, it brought a lot of public interest to this particular case, I beg your pardon. Now, the most important reason we can cite in this matter, Roland, is that this has to do with mining, galamsey. And you know that the topic of galamsey in this country alone is a huge matter. President Akufo-Addo campaigned on it. President Mahama campaigned on it. Throughout the presidency of Akufo-Addo, it remained a heated topic for discussion. Anytime it came up, it generated a lot of discussion. President Mahama stood on it. Members of the NDC stood on it. It dominated the campaign messaging and conversations. And so you cannot be surprised that a legal case that has to do with controversy involving a high-ranking political figure, businessman, would not attract the interest of the public. So it's not just, and when we talk about the public, we are not just talking about some civil society people who are environmental watchers or who are watching the public purse, who are watching the governance space or watching politics. No, we are talking about the so-called ordinary Ghanaian. We are talking about the people on the streets, and you are both legal people. We are talking about the man on the Madina Trotro who is interested in the devastation that galamsey is causing to the forest, the environment, the water bodies, the roads. That is how the issue of galamsey has gained traction in our public, political, and governance discourse. And so no one can be surprised and should be surprised that indeed this particular matter is churned out so much public interest. And Roland, there are those who have argued, and such people are watching keenly which way this particular judgment would go, and the weight of the sentence that would be handed down if the regional chairman of NPP loses this particular case. There are those who have said an example must be made out of Chairman Wontumi. There are those who have said that the court must make a statement that it does not matter your political standing, it does not matter your influence in society, it does not matter how much money you have. You must be held to account anytime you fall foul of the law. To such people, they are watching, and the scrutiny is on the court. There are those who have said that, look, whether he is a high-ranking political figure, whether he has money or not, whether he has influence or not, the courts must be seen to do their job. And the job is to examine the evidence. The job is to ensure that due process is followed. The job is to ensure that Wontumi has the opportunity, a fair, unfettered a hearing in the matter to defend himself in the charges that are brought by him, and that the prosecution, which is the state, which is the republic led by the Department of the Attorney General, that they are not cutting corners to convict him because they owe allegiance to different political parties, but that they are holding on to the horns of justice, ensure that the evidence as it is indeed speaks to the guilt or otherwise of Chairman Wontumi, and that whatever the outcome of this case, each party in this case, the Attorney General, the Defense Counsel, the accused himself, each one of them would have been seen to have played his role fairly and squarely. So we have that category of people who are also interested and also watching. Will the courts do their job? Will the courts do what is expected of them? And so, Roland, whichever way you look at this particular case, it's a case that it tests our resolve as a people to fight Galamsey. It tests the resolve of the state, i.e. the government of the day, to fight Galamsey. It tests the resolve of the court system to fight Galamsey, to see whether a man can get a fair hearing, whether a man is dealt with according to how much money he has in his bank account or how much influence he wields in society. So it doesn't matter where you stand, whether you are selling in Makola, whether you are a big businessman, whether you are a person with political influence. This case tests the resolve of the system and tells each individual who has an interest in this case or is watching this case whether indeed you can trust the system. So all of us, and indeed you and I as media practitioners and also as legal practitioners, we have an interest in this case to see whether all of the campaigns, the advocacy, the championship that the media has made. Don't forget, there's a media coalition against Galamsey, and this dates back to the era of, or the presidency of Nana Akufo-Addo. And there's a lot of work that media practitioners and media houses themselves have put into this. And I'm sure that we may not be able to say it into the microphone and into the cameras, but media people also have an interest in this case to see how the courts would deal with a case like this. Whether there will be justice, whether there will be fairness, whether the definition of justice will be different based on who is who. All those are things that people are watching to measure. So where are you standing? How are you measuring? What is your perspective on this matter? Depends on where you are standing, Roland.
Just be there, and we'll go to Joseph, and Joseph also will give us some due explanations on whether the court in itself, in trying to apprise of itself of what the latest issues are surrounding a particular case, will take judicial notice of events surrounding not only the case in itself, the facts, and then also the events outside the courts. And because of the influence of not only Chairman Wontumi, but also his company, this has taken another dimension, Joseph. And what will be the considerations the court would have to make in this? You know, our colleague made reference to the fact that this is a case of no mean proportion, a lot of interest. Yes,
absolutely. I mean, but just to answer directly, yes, there is the point about judicial notice that courts generally can take judicial notice of facts, but there are certain legal requirements, and this is provided for in the Evidence Act, specifically Section 9. It makes the point that the court can take judicial notice of facts that are generally well known within the territorial jurisdiction of the court. And so where the court sits, there are matters that people generally within the jurisdiction of the court know about. So for instance, a court, if someone is testifying and says that John Mahama is the president of Ghana, you will not expect another person to go into the box to lead evidence to show that John Mahama is the president of Ghana. This is a fact that is generally well known. The court can also, and the court can take notice of it whether it is requested for by a party or not. But generally, what a court is not allowed to do is to take judicial notice of matters that are subject to controversy, matters that the truthfulness of it cannot be ascertained, matters that raise controversy. There's a very famous case from the 70s where the court took judicial notice of what had caused inflation. The former member of parliament and former leader of the minority, J.H. Mensah, he had written an article where he had criticized their champion regime and how they had handled inflation and all of that. He was cited for contempt, and the court had taken the view that it was taking judicial notice that inflation generally were being caused by global factors and not the economic management that was taking place here in the country. The court said that when it went on appeal, the court said that those are matters that are debatable. Those are matters that are subject to controversy, and so a court cannot take judicial notice of such matters. And so generally, the answer will be that it will depend on what the court decides to take notice of. And I think a fact that Sixtus makes reference to, which we all know and we can't run away from, is the fact that illegal mining is a big problem in Ghana today. And that is a fact that the court very much well aware of and would operate within it. But we need to still insist that the question to be answered is whether the charges that have been leveled against Wontumi, whether sufficient evidence have been led to prove his guilt. Because the standard is you are proving it beyond reasonable doubt. The thinking is that where there is a doubt, it should inure to the benefit of the accused person. And so if the judge at any point in time of analyzing the evidence asks herself that, but could it be the case that he didn't do this? The position of the law is that it should inure to the benefit of the accused and say that, well, if I have a doubt about whether he did it or not, he should be allowed to walk. And so it's a very high burden that is placed on the prosecution in this particular instance. And it's one that they would have to scale that particular burden and provide answers by way of the evidence that have been led. And at this point in time, it's all done. Right now, what is taking place in the courtroom is the analysis of all what has transpired already. So the judge will now, has gone over the record of proceedings, has done all of that analysis, and has come to a certain conclusion, which the judge is announcing at this point in time, Roland.
And we know that subsequently then, it also means that the period for delivering the judgment usually would depend on a certain duration and then what the court has taken notice of, and then the sort of evidence that has come before the court. Is that not it?
Absolutely.
And so the duration varies.
Yes, absolutely. But I mean, there are some judges, and a lot of the time, judges also have their own style. I know a few judges, I mean, some of them are very popular judges, I mean, by the way. They prefer to read the entire judgment, and they especially want to do so when it's a high-profile political matter. So those are their judges who belong to that. The other judges, some judges also, who basically read the conclusions. And their position is that the facts are known. If you are covering the case, you should know the facts. The lawyers in the case know the facts. Those who are interested in the case, they know the case of the prosecution. They also know the case of the accused person as well. And so the only other thing that remains outstanding will be the conclusions of the judge, the analysis of the evidence, and the conclusion that the judge reaches. And so those judges can simply go for the conclusion. And if the judge had gone in that respect, we would have known the judgment by now. Clearly, that's not what she's doing. She's preferred to go through the entire judgment. And then I remember one of our criminal procedure lecturers always used to say that she wanted always to go through the entire judgment. So that she says that she always had an issue with journalists who came into the courtroom. She says, I always want to give them as much information as possible so that they can make sense when reporting on how and why I arrived at the conclusion that I arrived at. And so that is what is clearly playing out in this particular instance, that the judge is going through the entire judgment as well. And that is how come that is taking place in that particular manner, Roland.
Okay. So judgment is ongoing. And we know that we have Lord Asari. Lord Edu Asari is in there for us. And usually there are reasons why those outside are not permitted to go in once judgment is ongoing, sometimes because the room is full or the court setting is full in the first place, or also because judgment is being read and so the actions will need to take place. But over time, I don't know whether we still have Sixtus Don Ulo there. Sixtus? All right. But we already know from the narration of Sixtus that security is high but particularly for those who would tend to witness some of these cases, witnessing the beef up or the mass up in security, is because of the individuals who are involved. And Joseph, for your experiences in reporting on cases of such magnitude, usually depends on the personality, is it not? And then of high profile a case, particularly when it involves persons who are politically exposed.
Absolutely, absolutely. And I mean, you can imagine by this point in time that the courtroom will be totally full. And for those of you when we're watching the television, where Sisters was standing, it's actually the entrance into the law court complex proper. So you can't take the camera beyond that point. So that's what is in the shot now. So those are journalists. They are mainly the ones who handle the camera basically, and sometimes they are those who have come to assist the other reporters who are inside the courtroom. And so they are waiting. So what happens is that in front of them is where the lawyers and the various individuals will be exiting from. Let me bust our bubble a bit. We saw Chairman Wontumi going into the courtroom. The difference is that his exiting from this particular entrance will be dependent on the outcome of the case. In the event he's found not guilty, he's going to come out from that particular entrance. If he is found guilty, you are not likely to see him come out from that particular entrance because there's a service exit that mostly accused persons and suspects and convicts and all those people are moved in. And so this particular car that you see exiting from this side and entering the courtroom, if he's found guilty, he's not going to come out in that same manner. On the other hand, if he's found not guilty, he's going to exit in that particular manner. And so a lot of the time, that is what plays out over there. The security is generally heightened as well. There will be a team that is also available in terms of from the prison office, if depending on the outcome, once again. So the arrangement is always done first to safeguard the court environment. Because, mind you, this is a matter of a political nature. I mean, the normal cases that a lot of lawyers handle and go to and deal with in court, you are not likely to, when there's judgment, we just go and take the judgment and come back. But because of the high stakes and the political interest in it, you don't want a situation where the serenity around the place could be interfered with. So there will be officers on the compound just to provide protection to make sure that the court environment is safe and secure for everyone. Then there will be court warrant officers also inside the courtroom itself. There will be some prison officers who will also be on standby depending on how things play out over there. Then for the media men, you are just waiting outside to see how all of that is going to play out depending on the judgment that is handed down. But maybe at this point in time, Roland, we can just do an overview of some of the matters
because
that is
we've been speaking to the current matters as they are, the judgment being read, because before the court began the whole process of reading the judgment in itself or giving the judgment as we're reporting, there was the matter of the application, which was of course, then dismissed by the courts. But substantively, what are the charges the accused have been given so far? And then also, why are they being tried in the first place?
So basically, what we'll do is that first, an overview of the cases against him generally. This is not just the only case. Then we'll now narrow in and look at this specific case that is against him. And I'll just step a bit back here and just show you the screen just right behind me, just to give us a sense of how things look generally. There are a number of cases that are currently pending in the courts against the NPP's chairman, Wontumi. And the first one is the one that is, the judgment is being delivered as we speak now, and that is the Samreboi illegal mining case. The key summary, what we can tell you for a fact is he's alleged to have assigned his mineral rights without approval. And the court had initially set July 3 for judgment, which we already alluded to there. Then there's the Tano Nimri Forest Reserve case. In respect of that one, he's alleged to have mined in a forest reserve without permit. The investigator is being cross-examined in respect of that particular matter. Then there's the Exim Bank matter as well, where he's alleged to have fraudulently procured a 14.3 million cedi loan from the Ghana Import and Export Bank and caused financial loss to the bank to the tune of over 30 million cedis. Now, we know that with respect to the Exim case, there is a bit of a discussion ongoing between himself and the Attorney General on the possibility of reaching an agreement under the plea bargaining law. We know that the last update that I saw was last week from the Deputy Attorney General, Dr. Justice Remsai, who had indicated that as at last week when he was posting on Facebook, he had said that an agreement had not been reached on in respect of that particular matter. And so that is it in terms of that. But with respect to the various charges, I mean, basically the factual situation deals basically with issues relating to how mining took place in his mining concession without permission, allowing various individuals to undertake the mining. And that is what has been described as the unlicensed mining or undertaking operations without ministerial license. And that's basically counts 4 to 6, purposely facilitating an unlicensed mining operation. Now, this is an offense that generally, in terms of what it attracts, between 10,000 and 15,000 penalty units plus either a 15 or 25-year imprisonment. So that is it in terms of the punishment regime. And for those of you who are wondering, the 10,000 to 15,000 penalty units, because each penalty unit is 12 cedis, that will give you roughly between the amount of 120,000 cedis and 180,000 cedis, in addition to the prison sentence of the 15 to 25 years that I alluded to under that particular offense. There's also the bit about permitting or facilitating another person's illegal mining, basically assigning or permitting the use of concession without the necessary authorization. Under the old law, this carried 2,000 to 20,000 penalty units and 5 to 10 years imprisonment. But the new amended act has taken this up to between 30,000 cedis and 100,000 penalty units, with the accompanying sentencing regime being 15 to 25 years as well. And so those are some of the issues that he is dealing with or is being confronted with. And those are matters that once the court comes with its conclusion, the court would have to decide what the regime should be. And so maybe a bit more on the offenses. So the first offense under count 1 is the assignment of mineral rights without approval. That is contrary to Section 14(1) of and Section 99(2)(b) of the Minerals and Mining Act. Then there is also the offense of assignment of mineral rights without approval. It's also another offense there. Then there is also the offense of assignment of mineral rights without approval. Once again, so there are multiple counts of the same offense being there. And purposely facilitating an unlicensed mining operation is also another one over there as well. Then the count 5 again repeats it as another count because of the factual situation that the court is dealing with in the particular instance in terms of the allegations that have been put out by the office of the Attorney General. And so that is how things are looking like at this point in time, Roland, in terms of the facts, the charges that have been leveled against the NPP's chairman, Wontumi.
Well, currently we're providing you live coverage, and we know that the judgment currently is being read by the particular High Court that is on the subject of the case against Wontumi, particularly concerning mining activities and engagement within the Samreboi mining enclave. We also do know that there are other cases against him before the courts, which we have enumerated and expatiated, rightly so, on this ongoing coverage. But we know that pointedly what has been done so far is for an application by his lawyer for a deferred judgment to be dismissed by the court, and subsequently we have the judgment being given by the court currently. We have Lord Idwasari, who is in there, and then subsequently Sixtus Don Olo, also broadcaster, legal practitioner as well, also at the courts, and then also gauging what the public opinion is, what the atmosphere is outside the court precincts, and right here in studio, as we're also broadcasting and streaming live across TV3 Ghana and TV3 Mainstream, and then subsequently 3 News. Make sure you get the latest when it comes to this, not only on TV3, but also 3FM, as well as all of our social media handles. Get the latest. Let's know what you think about what's ongoing currently at the courts, but more importantly, what you make of the case and whether you have followed the coverage of this case over the last couple of months or since the whole of last year, and what you make of it Of course, if you're a supporter of Chairman Wontumi, it also means that you have an interest, you have an opinion to share. But substantively, on the case itself, what we're doing is also make sure coverage is within the remit of the law, what is permitted, and so bring you the facts as they are, and then also what charges have been leveled against Chairman Wontumi. Entry Boisiakon goes by the first name Bernard. We know that outside the court, he's the chairman for the MPP for the Ashanti region. Just to also add that he's also making a bid for the national chairmanship of the opposition MPP as well. But the case has generated or elicited a lot of interest. And Joseph, let's go through some timelines, particularly for this case. Absolutely.
And it's just a recap of what we are doing. If you are just joining this coverage, is our build up to the conclusion of the judgment that is currently ongoing at the High Court. The judge is delivering her judgment, and very soon we'll cross over and give you the very latest on that. In respect of all what has been playing out so far, we start from October of 2025. Now, in October of 2025, Chairman Wontumi, Akonta Mining Limited, and another accused person, that's the Kwame Entry gentleman I made reference to, were charged with offences relating to alleged illegal mining activities at the Samreboi concession in the Western region. The charges include facilitating unlicensed mining and assigning mineral rights without the required ministerial approval. So that was in October of 2025. Now we go over to January, specifically on the 12th of January 2026. That was when the High Court commenced hearing the criminal matter, this particular case. The witnesses for both the prosecution and defense subsequently testified over several months. And that is important because that is how the case of this nature proceeds generally. And so first you have the prosecution call its witnesses to come and testify. Once they are done, there's this whole back and forth over the submission of no case, basically whether the accused person should be called upon to open his defense or not. We know that the court took the view that Chairman Wontumi had to be called upon to open his defense. So the defense in June of 2026 called its fifth and final witness, Evans Adai, officially closing its case. And so the High Court initially fixed the 3rd of July 2026 for judgment and directed both parties, that is the prosecution and the attorney and the defense lawyers in this particular matter, Chairman Wontumi's lawyers, to file their written addresses by 17th of June. That was the initial date. Then the deadline, that was the deadline for them to also file and submit the final written arguments to the court as well. We also know that Chairman Wontumi changed his lead lawyer from Andy Apiakubi to former MP Samuel Atachian, who requested more time to study the record and prepare the written submission. Then on the 29th, the court granted a request for additional time, and so the defense was given up to the 13th of July to file its written address, and the judgment date was now moved from the 3rd of July to the 20th of July 2026. And the deadline for the July 13th was when the deadline was for the written addresses to be filed. And today we are telling you that the High Court is expected to deliver judgment after considering the evidence and written submissions from both sides. I want to step back a little and just stay in here with this particular point. And this is very important because we expect the discussion that will come after the judgment, Roland, will center around the question of whether the judge could have held on and allowed Samuel Atachian to show up and come and address the judge on the question of whether the issue around the case raises matters that requires a referral to the Supreme Court. And those who would disagree and say that the judge was right in proceeding will make reference to basically what they would say is a leeway that the court had basically granted them, in that one originally was supposed to deliver judgment on the 3rd of July, but they pushed it by some 17 days to the 20th of July to give Mr. Atachian more time, only to be hit by this motion that had been filed by Mr. Atachian. He filed the motion. He was given a date to come and move the motion on the 20th of July. Then he now writes to the court to say that, well, he had a prior arrangement and he's out of the jurisdiction. He'll come back on Wednesday. And so the matter should be that, well, she's proceeding nonetheless. And so it's an important factual aspect of this whole discussion that would come to depending on how it goes out, Roland.
Well, so far, we have our reporter in the courtroom itself, monitoring proceedings, our regular Lord Eduasari. We're live right here on TV3 3FM. You can also get the latest 3news.com and let us know what you make of this coverage broadly. And we also have our own reporter, also broadcaster, legal practitioner, Sixtus Don Ole's judgment that is being delivered. So far, we know that the judgment has moved from count 1, 2, 3, and now the judge is on the 4th count. And we will apprise you of the latest as and when we get it from our key reporters. Now let's go to Sixtus Don Ulo. You find that as we're giving this coverage, it also means that we're also having a number of individuals across social media who are also following mainstream and in real time. The question then is, outside the presence of the courts, what's happening? Sixtus.
I'm sorry, Roland, say that again.
So generating massive interest, not only mainstream, but also on social media. A number of individuals have hooked on to the coverage so far. Outside the precincts of the court, what's happening? Have we seen some key individuals of the MPP particularly who have been shuffling in and out of the courts literally on the subject matter of the judgment being delivered?
Not really, Roland. As I mentioned to you earlier, typically in cases like this, you would find members of the particular party that the accused belongs to. These would usually be high-ranking members of the party, very influential, with a high voice, the kind of voices that every media person would want to engage. Indeed, in this particular case, when it first came to court, we saw that the first few court appearances, he was accompanied by party executives at the regional level, at the national level. He was accompanied by people who, have a voice in the party. But today is not like that. As I scan across the terrain here at the High Court complex, I don't see any of those people. I think that we would have some of the people already seated in the courtroom, but that would be it. And the courtroom is not enough to contain all of them. So I expect to see some national executive members inside of the courtroom. I expect to see a few regional executives inside of the courtroom. I expect to see some representation from the parliamentary caucus inside the courtroom. But even all of that, taking into consideration the size of the courtroom, we are not looking at more than 20 people or, if you like, 20 people from the NPP who would be here inside of the courtroom. Because the courtroom in itself is not spacious enough. And it has to take journalists, take other party or other people who have interest in other cases in the courtroom and all of that. So we will not have a courtroom packed with party members. As for the outside here, in the yard of the court complex, we don't see party people around. Largely what we have are media people and lawyers who are done with their case and they are coming out and taking their leave from the court premises. So the conversation will largely be on social media and reliant on outlets like ours to inform them. Now the difficulty or the only thing we should be worried about with that social media conversation would be the likely misinformation that this would generate. And that is why we have to be timely also with our broadcast, so that people do not get misinformed in their efforts to follow the live feeds and to understand what really is happening in real time. The social media conversation is such a way that you would often have people who jump onto it. They jump onto it from all sides. They probably don't even understand what exactly it is. You just mentioned count 4. What does that mean to the ordinary social media person who is following the conversation? May not understand, but will jump onto it and try to interpret for his or her followers. That is where the real danger is. Again, as to whether the party members are massing up elsewhere, maybe there's some communication to them to meet somewhere else, maybe at the party office, that we do not have information. But within the immediate precincts of the court complex, we don't have such people gathering. We don't have them. And as I said, even the security detail here is not so heavy. That probably is because intelligence would have suggested that we don't anticipate any massing up of people, any unnecessary commotion and all of that. People are following, yes, largely from social media, largely from our own outlets. And we'll just encourage all those who are following to follow us also on our social media platforms for detailed, accurate and fair reportage on what is happening here at the High Court complex.
And just to also bring up to speed what we're also monitoring from the courtroom as this judgment is being given, we also know that referrals have been made to IDs that are said to have been not only misplaced, but more importantly, seem to have been faked as well in relation to the interested persons in the matter, as well as related to the directors of the company as part of those accused in this case as well. And then moving on to the subsequent issues, it also means that the interested parties would have to also be aware, all interested individuals for this matter will have to be. This is what we're going to do. We're going to make sure that for all those interested stakeholders and politically exposed persons, either close to the accused persons or the company or the entity, as part of those accused in this case, we'll make sure that related to this coverage, we also are able to touch base with them. And rightfully, we have to make sure that we go to the base of the Ashanti region, where we know that Chairman Wontumi, Bernard Inkribo-Esiakon, aka Chairman 1, is also the chair for the MPP for that region. We'll take you to our lead reporter, the one in charge of our bureau for the middle half of our country, Evans Inkum, to give us the latest. But Sixtus, when such a coverage is being given, it also means that we have to stay onto the facts of the case. And then for those individuals either connected to the case who are reporting on the outcome of the case or the judgment that's been given on social media but are in the courtroom, usually are there comments from the judges maybe taking notice of what is happening outside to caution the parties who are present in the courtroom? Have you had experiences like that? And so tend to caution them as to the references they make when the coverage and the judgment is being given on the matter of the content of that judgment to the outside world, so to speak.
Indeed, Roland, there have been instances in other cases where the court has been moved to directly caution journalists reporting on such cases. The immediate one that comes to mind is what became known as the coup plotters case. And indeed, one of the pressmen who reported on that matter at the time had to be called up in open court by the judges, and this was a panel of 3 judges, based on the report of one of the lawyers in the matter that the report that had been churned out or reportage on the case had not been fair to one of his clients. And it was a true test case of journalists who are reporting from the courts, whether they understand the issues themselves that they purport to report, whether they understand the processes of the court, whether they understand the implications of what is said in court, and how they report on such to their viewers or readers. So that has come up before. In fact, there are journalists who have been taken on. In the particular instant case that I'm talking about, the reporter, this was a reporter for Daily Guide, he had been brought up in open court and told that, based on the allegation of the lawyer, that the reportage was not fair. And the lawyer actually wanted the court to hold the journalist in contempt. But every single trained journalist who is reporting from the courtroom understands. You know, the court itself has, the judiciary has a press corps, and members of the press corps are trained to understand the processes and the implications and what is said in court and all of that. What saved this particular reporter that day were his notes, the notes that he took in court whilst the proceedings were ongoing. So the court requested those notes, and the presiding judge, Efia Sewa, every law student knows the lady Efia Sewa, every lawyer knows the lady Efia Sewa. You know how strict she is, you know how principled she is. The lady Efia Sewa called up this journalist, Razak, Daily Guide, requested his notes, went through the notes, and retorted, "Oh, but this is even more detailed than the notes that have been taken in my own courtroom." And this was to the applause of the media then. And that was the thing that saved him. Because the court has become very apprehensive of what is reported out there, especially in cases like this where a report is made and on social media, everybody takes the judge to the cleaners based on a single report, a report which may have been misleading, may have been misconstrued by the reporter, misunderstood, and thereby misreported. And so the courts are beginning to look very stringently at people, media people who report from the court, and they don't take kindly to it. So yes, I wouldn't be surprised if such caution has been issued. And I wouldn't be surprised if such monitoring is already even being taken. But you would also know, Roland, that the moment the judgment is delivered, the court becomes, it loses the power, it discharges the responsibility, so it does not have the power over that same matter again. And so there may not be the opportunity for the court to come back and call any reporter or journalist before the court and try to hold that person in contempt. There may not be that opportunity. But there may be other opportunities that are open to whichever party feels maligned in that particular case to take the matter up to a different forum within our system. And so, yes, you are right. The caution would be to those of us who are reporting from the court that as much as this is a high interest case, that for a lot of us, we want the clicks and the views, that is all we are counting. But we also owe a responsibility, a duty to ensure that what is reported is fair, is accurate, is detailed, and does not leave room for misinterpretation. That we report what we actually know and what is actually been said in the court, and leave the interpretation of the report to the parties or the fora or the people who have the capacity to do so. Which is why I will come back to the point that for all of our viewers and listeners on radio, if you are stepping out, you don't have the time to continue staying glued to your TV, we are live on Facebook, we are live on YouTube, we are live on X. Stay glued to TV3 and 3FM.
Podcaster, legal practitioner, also helping us explain the matters. What we also would do, and Joseph Akable has already talked about that, also try to again go through what the contrary offenses are, and then also what the punitive sentences could be. And it includes a fine as well as a prison sentence. Now, what's the maximum cap? And then also what penalty unit are we talking about if you contravene that section of the Minerals and Mining Act? And so on that subject matter, again, there are interested key stakeholders. We've talked about where he is currently the governing chair. So the chairman for the MPP for the Ashanti region, and as an accused in this subject matter or this case, it also means that there are interested parties from the locale who will be very much interested in this coverage via TV3, 3FM, across our social media handles who are currently watching us. And we told you that we'll let William Evans Nku, monitoring the situation in the Ashanti region, give us the latest. Where are you currently in the Ashanti region as you have deployed yourself? What are you getting so far? Interested individuals for Chairman Wontumi, and then also the MPP in the subject matter involving their chair. William Evans Nku.
Well, thank you, Roland. So currently, I'm here at the Hasta Lodge, and what is happening here is the first day of a vetting of interested candidates who want to lead the Ashanti region, leadership position, executive leadership positions, as far as the position New Patriotic Party is concerned. Like you rightly mentioned, this is their stronghold, and when it comes to matters which has to do with a leader of the party, for that matter, the Ashanti regional chairman of the party, there's some level of keen interest. So here, you will say somewhat divided attention, in as much as people are also focused on what transpire at the vetting committee or at the vetting. There's also so much interest in what also happens at the court, that is the Accra High Court, as Wontumi. There's going to be some like called the final adjudication of his Samreboi case. So there's some level of interest, wanting to know what happened. But then they will not share their sentiments on screen, but out of screen, you can see them getting information on their phones from people who are also reporting to them, talking about party members who are currently at the court and also feeding their colleagues here with information. So that is what is happening here at the Hasta Lodge. Right.
Now, to the extent that this has generated that level of interest and the way you perhaps observe and explain it, would you say this very mixed reaction so far?
Well, mixed reactions as in being hopeful that the judgment will go in favor of Wontumi. But there's few who are also skeptical, looking at the magnitude of them. But a good number of them that have engaged believe that the judgment will be favorable. But from their pushback, it tells one thing, that, well, their inner feeling appears to have a different view. But expressing their views to you, they are hopeful.
William Evans Nku, explaining things there. How big is Chairman Wontumi in the Ashanti region? And then you take a look at the travails of his political life so far. He's been chair. You take a look at the constituency where he was chair and then becoming for the Ashanti region, winning power for the MPP, and now at the same time said to have supervised the party going out of power into opposition in the first place, but now vying for chairmanship of the party. How does that perhaps also add up to what public opinion says about him and then his involvement as an accused in this case, as well as the other string of cases he's involved in?
Since the inception of the party in 1982, Wontumi is among the few individuals who have gone through the process. Having held position at the grassroots level, rising to becoming the constituency chairman, then right from there, bam, to becoming the Ashanti regional chairman of the party. You'll say that, journeying through his political career, it is very obvious that he's one person who is very popular, besides being loud in terms of his political views and what have you. So in terms of popularity, you cannot take anything away from him. And of course, we also know that his popularity goes beyond the borders of the Ashanti region. At the point in time, I can't remember in the previous administration, we also had Focus, regional chairman, and I know that he once served as the chairman of the chairman, Focus, as far as the MPP is concerned. Then you also not forget, 4 years ago, at the Ohinijan Sports Stadium, now Accra Sports Stadium. You remember that interview that Mawena also did with Kennedy Ohine Ejapon. And I mean, it's view that we shared right after that particular national elections, also which saw John Bodu lose, I mean, his position to now the chief stripe of the party, Justin Kodia, Wontumi view and all of that, having quit the chairman, but unfortunately it didn't go their way because eventually Justin Kodia won that particular race. So it tells you how influential Wontumi is. But nonetheless, there are other areas that he has also fallen short, and which has also created some level of, I wouldn't call it enmity, but it's affection for him. How he also managed the party in the Ashanti region, some of his critics believe that it wasn't done in a way that they expected. Especially those of his critics believe that they were sidelined and what have you. But the other people also are then supporters of Bernard Enchibo, who also believe that he also has done a lot for the Ashanti region, because if you look at, I mean, his record as Ashanti regional chairman in terms of nominal figures, yeah, you say that there has been some level of appreciation as far as the MPP performance in the Ashanti region. Mind you, in 2016, he was the chairman of the party here in the stronghold of the MPP when the party won power. In 2020, even though percentage-wise the party did not perform or showed some impressive figures, but we are talking about nominal figures. Then you say, hey, we did well. Compare the Ashanti region figures to the other regions and what have you. So yes, hot and cold. If you are to describe Wontumi. Nonetheless, he also commands some level of respect, despite the fact that he also has some level of shortcomings.
Okay, keep monitoring the situation for us. As and when, again, we want you to give us your perspective, and then also you have key interested persons you would want to speak to. We'll bring you again on board. But Joseph Akable then will take us through what the offenses are, but also what the charges for which we're having this judgment being delivered by the court, rightly so. We have a man in court, just monitoring the proceedings so far, Lord Idua Sari. He's our lead court correspondent. Also, we've beefed up the team on the premises of the court. Sixtus Don Ulo, also broadcaster, legal practitioner as well. And right here we have Joseph Frimpong Akable, same accolades. And just to give us a perspective on this, just to broaden the coverage for you and then also give you, please, if you're on social media, make sure you share the stream. Let's have some great conversations ongoing. And then if you're monitoring also, what's your own perspective about the coverage of this, what the outcomes have been for each of those sessions that we brought you those coverage by way of the proceedings on this case. And finally, we're witnessing this judgment being delivered at the courts. Us in real time as we're covering this as well. And so Joseph will take us through. But just to apprise you of why Chairman Wontumi or Bernard Enchibo is in court, we will again take you through the brief facts and then also take you through what the charges are and what currently we're witnessing. And premises from the premises so far, this is what we have, and this from the court right here, court complex as we have it. And Joseph, interested individuals coming in, trooping in, but they are not in there only for the case for Chairman Wontumi, are they?
No. And Sixtus correctly identified it. It's the law court complex. I mean, 5 floors, so many courtrooms. In fact, the land division alone, there are as many as 9 land courts. There are general jurisdiction courts as many as 6. There are multiple commercial courts there. There are also the financial courts also that is also there as well. And so there are so many courts, there are so many activities that are ongoing there. But for a lot of the press, people who have gathered, and for a lot of Ghanaians following us from different parts of the country, what they are looking out for is the Chairman Wontumi one, the Samreboi mining judgment. So this is the entrance of the courtroom, and you see those who are coming out from the right-hand side and those who are going on the left-hand side. So that is how it plays out there. And I had made a point earlier on that depending on the judgment and the conclusion, he may not exit from the right-hand side on our screens as we are seeing it now, because there's a service entrance where mostly persons who are convicted of various offences are taken through. On the other hand, if he's found not guilty, we expect him to come out from that side. We understand that.
So in the middle, on the screens, or the extreme right?
The extreme right. So the one on the left is where you enter in. That's where you enter on the left. So
that's the entrance.
Point. Yeah, so the exit is where the old man just came out now, the elderly looking man. So that's the exit point. We understand that the judgment's at a significant level now. We would be providing some important updates very shortly. But with respect to the question on the punitive nature of the offences that's been charged against, there was an amendment that we did in the year 2019. Was actually signed into law on the 19th of August 2019 under the previous administration. And basically what it does is it puts the punishment regime for most of the offences that is charged with, basically, is between 15 and 25 years. And in terms of the penalty, it's between 10,000 and 15,000 penalty units. Each penalty unit is 12 cedis. So that takes us between 120,000 and 180,000. And the two come together. So it's not those offenses that are optional. You know, there are some offenses, mostly the misdemeanors, you'll be told that 100 penalty units, or you can be sentenced to 6 months imprisonment. In this particular instance, the punishment that it comes with, the minimum is 15 years, maximum is 25 years. And in addition to the prison term, you will be slapped. You can also be slapped with a fine, and so it is together. So in addition to that, 15 or 25 years between, you can get the 120,000 cedis or 180,000 cedis imposed on you as well. And the framers of the law are always taking the view that because of the impact of the mining activities, if it's not done in a sustainable manner on the environment, it's only fair that some amount of money is also recovered. So the breaking news that we can report at this point in time, coming from our court correspondent in the court, is that Chairman Wontumi has been convicted of assigning mineral rights without approval and purposely facilitating illegal mining at a Samreboi concession. Count 1, assignment of mineral rights without approval. He's been found guilty beyond reasonable doubt that there was no ministerial permit obtained, so he's been convicted. Count 3, he's been convicted as well. Count 4, guilty as charged, convicted. And count 6, purposely facilitated an unlicensed mining operation. And so the update that we can provide for you, the breaking news this hour, is that the NPP's Bernard Entry Boesiako alias Chairman Wontumi has been found guilty of various mining offences by the court. And at this point in time, the plea of mitigation is what is taking place at this point in time, Roland.
And it's also important that during the plea of mitigation, that again will be led by his counsel.
Yes, I actually checked, and I have an update on respect of that as well. I checked with Lord because we wanted to confirm whether he had lawyers present. Lord says, in actual sense, 4 of Samuel Atachen's juniors are present in the courtroom, and they had attempted to actually address the court on the motion for the deferment of the judgment. But the judge had taken a view that because the motion and the affidavit had been filed, she had read the entire process and she was satisfied that this was not a matter that required a reference to the Supreme Court. And so if you are just joining us, the breaking news at this point in time, Roland, is that the NPP's Chairman Wontumi, Ashanti Regional Chairman of the New Patriotic Party, has been found guilty of various mining offences. The court is satisfied that the state has proved its case against Chairman Wontumi beyond reasonable doubt and has convicted him of the offences found against him, Roland.
It also includes his company, that is also an accused interested entity in the subject matter, and they also, when it comes to the count, can be found in count 3. Again, we also know that for facilitating unlicensed mining operation, also found guilty, but more importantly, we also have to, within the remit of the law, assignment of mineral rights without approval, found guilty beyond reasonable doubt that was undertaken, an act and omission, and that also means that for all that has to be said, we've also brought you within what the sentencing regime is, and then also what the judge could look into in assigning that sentence. And the sentence against Joseph includes a prison term and then also a fine.
Yes, absolutely. It comes with a prison term and a fine as well. And at this point in time, the mitigation is what will be taking place. And like I did explain earlier on, the mitigation is basically your lawyers addressing the court to convince the court that, especially because for offenses that has a range of punishment. So if you are looking at 15 to 25 and you're looking at 120,000 to 180,000 cedis as the fine that could be imposed, they now have to urge the court why the court should not go for the upper limit, why the court should come a bit low. And so a lot of the times what the lawyers will do will be to say that, well, this is someone who is an important person in the community, is a first-time offender. In fact, the first-time offender, the lawyers will say he's not known to the law, meaning he's not had a brush with the law, so that he's been convicted before. It's always a very important prayer that is made because it should let the court know that, well, maybe it's not someone who is a criminal, so to speak, engages in various criminal activities, but it's the first time that the person has engaged in such an offense. You make the point that, well, he's ready and willing to do some restitution, maybe some the money that the fine that could be imposed is ready to make the money available immediately. The state will not have to go an extra step to try and enforce that aspect of the judgment, etc., against him and all of that. But all of these are matters that the judge would also take into consideration the facts that have been proved as well. And your own plea is the reason why sometimes some lawyers would advise that if you know you've committed the offense, it's fair that you plead guilty at the start, because then you've allowed the states to expend prosecutorial resources to prosecute you all this while. And so that is also another thing that the court would also look out for. And so once they address the court on a plea of mitigation and they are done, then the judge will now come and announce the sentencing, and that will bring an end to the proceedings for the day. And so just by way of a recap with what we are reporting this hour, the breaking news that we are reporting this hour, Roland, is that the High Court has convicted Chairman Wontumi of assigning mineral rights without approval and purposely facilitating illegal mining at a Samreboi concession. Count 1, assignment of mineral rights without approval, found guilty. Count 3, Akonta Mining was also convicted as well, the company. And count 4, guilty as charged, Chairman Wontumi convicted. And count 6, purposely facilitating an unlicensed mining operation has also been found guilty in that respect. We will try and connect Roland as well to the Ashanti region. At least by now, they are watching us right here on TV3. They know I'm telling Roland we'll be connecting to the Ashanti region as well, Roland, just for the very latest in terms of the reactions, because they had gathered over there as a show of support. Now they are watching us live from the Ashanti region. They know what the decision now is that he's been convicted, and what we can assure them is that he's not coming home today because of the judgment of the court, and so he will be within the bosom of the justice jurisprudence administration for today.
Do we still have that focus on the door of the court area? Okay, so, but again, we know that there are interested parties because Chairman Wontumi, Bernard Intriboisiakon being his real name, is a politically exposed person, currently occupies the chairmanship position of the opposition MPP, but also operates a number of companies within the mining sector as well as its derivatives. But more importantly, is also vying for the chairmanship of the MPP. We know that when it comes to the MPP, the hub of the party is the Ashanti region. Early on, we had Bureau Head, that William Evans Inkum, take us to the Ashanti region and then speak broadly on his own opinion, but importantly, reported observation about the interested stakeholders, why they will be interested in this subject matter or this very specific case. And now the judgment largely has been given. We have the period of sentencing mitigation that will be led by his counsel or a team of the lawyers, and then also what that could also mean in terms of its trickling effects on public opinion in the Ashanti region. We'll have to bring him back again. William Evans Inkum, I'm sure, of course, you've heard the breaking news. That also, I'm sure, is also being communicated across the airwaves and social media in the Ashanti region. So far, what can you tell us? Right. Again, this is what we have. Joseph will take us through what we have, the breaking news, and then we also know that what has been, again, read out so far in this judgment by the court in the conviction of Chairman Wontumi. And just to apprise you, so the open door,
the one on the right,
on the extreme right, where the gentleman in ash is coming out from,
is the exit. Then the entrance is on the left-hand side. Okay. And so very soon we will see the lawyers and our colleague Lord Edward Sari and the others will be coming out on the right side, and then the Attorney General, his team will also be coming out from the right side. Hopefully we'll get some good interviews with them. We'll get an interview actually. We'll get an interview with them on all these matters and hear from the state's position on what has transpired in court so far, especially what they make of whatever sentence the court will be imposing. And I think in all of this, we had made reference to how illegal mining has been a topical issue, has been an issue of national concern so far. And Akonta mining is also important because if you recall, the Media Coalition Against Illegal Mining actually petitioned the previous administration on the activities of Akonta mining in the Samreboi area and even within the Nimri forest as well. And if you recall, the then president at the time, Nana Dankwa Akufo-Addo, had said that they were not engaged in illegal mining at the time. He said they were not engaged in illegal mining to his knowledge. And if you recall, the Lands and Natural Resources Minister explained that what Nana Dankwa Akufo-Addo, the president, His Excellency, meant was at the time he was speaking, they were not engaged in illegal mining. But be that as it may, the group actually compiled images of the illegal mining they believe were taking place. They sent all of that over to the police CID for investigations to happen. Nothing progressed or nothing came out of that. And it's something that in the course of various news bulletins we'll be hearing from some of these interest groups, and they will make the point that they found that to be very surprising and raised concerns that it did appear that the government, the previous government, was not bent on looking into the matter or prosecuting the matter because of the role and the individual that was involved. Then all of a sudden, a change in administration and the same facts, basically the facts surrounding his activities in the Samreboi area has now formed the basis of a conviction, a finding of a court as a matter of fact that there was illegal mining taking place in the Akonta mining reserve that had been handed over to the Akonta mining concession that had been handed over to Chairman Wontumi. And so that begs the question, and it's one that eventually, when it all settles down as a nation, we would have to have conversations about it. Because on the flip side too, one would also argue that, would it also mean that there was actually nothing wrong taking place and that because of the political witch hunting that perhaps is taking place? But either ways, a court of competent jurisdiction has been seized with a factual situation of the matter. They've heard from the accused persons. They've also heard from the prosecution. The court's conclusion is that there was mining that was taking place contrary to law in Chairman Wontumi's mining reserve, for which reason he has been found guilty of the offenses that he has been charged with, Roland.
Okay, just also to give you the timelines, this case particularly is just one of 3 other cases. And again, Joseph Akable, just to do a recall, took all of us through the number of cases that Chairman Wontumi is involved in. Of course, we'll talk about the concurrent prosecution of those cases as he is now going to be either imprisoned but also jointly also fined as well. And then also the time travel for this particular case started in October last year, 2025, and subsequently a number of evidence adduced as reported by our court reporters over the period of this case, to the point that we even had his general manager also turning a witness for the prosecution in itself, and subsequently we know a number of incidents that have taken place even outside the court room itself in relation to the subject matter. And that also means that a lot of interests have generated for this case, and interested parties, interested stakeholders, particularly associated with him as a businessman, also as a politician, because currently he is the chair for the MPP in the Ashanti region. And it also means that those interested parties, particularly politically exposed persons, will have a lot to say. And just outside this case is the fact that Chairman Wontumi, Bernard Enkriboi-Siako, is also vying to be the chair for the MPP at the national level, so the national chairman prospectively for the MPP. But we'll subsequently again take a look at what rights are accruing to him in law after this judgment, and then also how far that could go, and subsequently what effects that could have on his bid to become the chair for the New Patriotic Party nationally. And Joseph, it doesn't look easy, but it also means that the public opinion certainly would also influence the outcome of this case, irrespective of how we make of it. A court of competent jurisdiction, but of course, in the court of public opinion, a lot of comment tend to go on the subject matter. For you, you've gone through the processes of being a court reporter and subsequently operating within the precinct of the court as a court officer as well. What usually goes in the minds of the members of the public when you're reporting it, and then also when you hear from the court officers, whether it's a registrars or even the judges themselves who sit on some of these cases, per your experience?
I mean, it's always interesting. It's always interesting, and especially for the public interest ones. They are the ones that come once a while, and so they are the ones that you always follow keenly. You are interested in. You want to see how it's all going to play out there. And in this particular instance, it has so much around it that makes it for an interesting following. And you've made reference to it extensively about Chairman Wontumi's own pedigree as a politician, to the extent that he wants to contest for national chairman of the opposition New Patriotic Party. And it's an interesting aspect of it. But a lot of the time, at this point in time, once the judgment is delivered like this, for the lawyers, what we would want is to see the judgment to understand the analysis a bit more and see how the evidence that was led, how the court placed weight on it, what weight it didn't place on it, and the various questions about whether they were sufficiently proved and everything. I mean, because I mean, the facts of the matter remain that all lawyers go to the same law school, but they come out and they all disagree on different things. Last week Friday on the show, one of the texters, he sent a message that lawyers interpret the law like the Bible, because pastors, they read the scripture, you can give to the same pastors and they would
depending on the inspiration they have from God.
Exactly. And so
which God?
I mean, so all those are things that the lawyers tend to look out for. I mean, for those who are in the general public, I mean, and a lot of the people, some of the things that they are saying now, in fact, I can guess what's on the mind of many people now. They just want to know what the sentencing is at this point in time, and it's why we.
Well, you take us through again, just to apprise you of what the latest has been. This is breaking for a number of minutes now, and rightly so. We're having this coverage, not only mainstream, TV3 Ghana, across social media, 3FM 92.7 across social media, 3news.com is where you're getting all the latest, whether it's on Facebook, TikTok, YouTube, and X, as well as all the others. You can find the latest breaking from Media General, MG, and 3 News. We're bringing the latest as it is from all our platforms, in all the subsidiaries as well. The latest being Chairman Wontumi, Bernard Intwi-Boesiakung, an accused person in this case, has been convicted, and for which conviction we'll apprise you of. And Joseph,
yes,
we have them.
Just before that, I mean, a bit of we are doing a live coverage, so live updates now. Some of the things that are being said in court by way of the plea mitigation that is taking place, and so the Chairman Wontumi's lawyers, they are saying that he is the breadwinner of his family. They are saying that he is married and has dependents, and so they are asking that. They should be given a lower sentence, and we've already pointed out that the minimum is 15 years, the maximum is 25. They also say that Chairman Wontumi is a law-abiding citizen who always showed up in court as well, and so the judge should also consider that as well. And we must indicate that the court was first addressed by lawyers who are from Samuel Atachian's law firm, specifically Charles Boachi Esquire, who is the one who was on his feet first to address the court. In fact, he's the lawyer who authored the letter that was sent to the court that Mr. Astachian was traveling, for which an adjournment should be given. So he's the one who addressed the court. Afterwards, other lawyers in the courtroom have also taken turns to address the court as well. And then one lawyer, Bernard Redudonko, also addressed the court, urging the court to be lenient in terms of the sentence that it should impose on Chairman Wontumi. He announced himself as a friend of the court, Bernard Oredu Donko there, saying that some leniency should be applied in this particular instance to Chairman Wontumi. So those are some updates that we are bringing you from the court room in terms of the updates. And in just some very few minutes now, when the judge is done hearing from all those who would want to address her on this particular matter, she will put down her sentence, then it will be read to the public and we'll update you in respect of that as soon as we have it there. And then a lot of the times, when you have multiple offenses, Roland, there's always the question of whether it should run concurrently or consecutively. If you are not lucky and the judge takes the view that it should be consecutively, then if you are found guilty for maybe count 1 and also count 3, and count 1 is 15 and count 3 is also 15, it will mean that you are going to do 30. On the other hand, if the judge opts for concurrently, what normally happens, and the very simple way of understanding it, is that you pick the highest figure. And so there can be multiple offenses with various years. One can have 15, one can have 20, one can have 30. All you have to do is to pick the highest in it. So if the highest is 20, then basically it will mean that you'll be in for the highest figure, which will be the 20. So the count 1 is the undertaking the mining operations without a license. Then the count 4 is felling trees in a forest reserve without authority as well. Then count 6, erecting buildings in a forest reserve without authorization. And as we are well aware, he pleaded not guilty to all the counts. Then the bit about the undertaking a mining operation without a license, abetting the unauthorized felling of trees as well is also another offense that came up quite strongly there. Also pleaded not guilty in respect of all of that. And so that is how far we have come in respect of this particular matter as well. And the plea of mitigation is still ongoing as we speak now at 11:35. Other lawyers are still addressing the court. They've taken an interest in this matter and urging the court to be lenient. And like we said, the range that the court is working within is 15 to 25 years. And so the judge would have to do the analysis to decide. And she would also have to answer the question whether she thinks it should be consecutively or concurrently. That's another question that the court would also have to answer as well. Then there's the fining bit that accompanies it. With that one also, we are also saying that the range is the 120,000 and the 180,000 as well. And so that is the range that the judge is operating within. And all these questions about he being a breadwinner and the impact it will have on a family, a first-time offender, all of this will be playing out on the court's mind. But this brings an end to a very significant high-profile public interest prosecution that has been taking place. And in terms of the prosecution so far by the state, this will be the very first one that they followed through under this administration from start to end and secured a conviction. And we'll be hearing from the legal team, the Deputy Attorney General, who has been leading this prosecution right from the start, the learned Dr. Justice Remsai will be coming out. We'll hear from him after the proceedings have come to an end. We'll also be hoping to hear from the legal team for Chairman Wontumi as well to address us on what the next steps are. One of my seniors always has a story he shares about how whenever he was going for such criminal matters, he prepares a notice of appeal. He prepares a notice of appeal. Everything is done, signed. Yeah. It just left to be filed. And once he sees that the judgment is not going in his favor, he can quickly just proceed and have the clerk
we'll go through what rights are accruing to him as an accused person, subsequently now convicted, and then also what steps his legal team could take in law to be able to perhaps seek a further prey to the courts, and then perhaps ask for some mitigation when it comes to the sentence or the outcome as it is. Again, we told you that high profile, a lot of interested individuals and parties to this very case. Already over 1,700 of you on Facebook and watching us currently. A number of comments also coming through with a number of individuals. Prince Nyania York is a regular watcher from the UK. He's watching on his device as well. I see Kelly. I see our own is also watching. Adi Diamond, I see you as well. Ni is also there. Noel, I see you. And Chikata is watching. And then Delasi Godwin, as well as a number of individuals across our social media platforms. We took you to the Ashanti region. Evans Nkom, the latest. Now we have this breaking. And not too good for those who support Chairman Wontumi or Bernard Intribuesiakon, the chair for the MPP in the Ashanti region, vying for the national chairmanship position of the New Patriotic Party. You're in the heart of the MPP, the Ashanti region. The sentiments, well, good, not good. But what are they saying?
Well, so most of them have been trying to avoid the microphone and the camera. But, I mean, behind the screens, they tell you that they're not happy about the development from the Accra High Court. They are not optimistic that at this juncture, there's going to be any escape as far as the corridors of the law is concerned. Nonetheless, we're also hearing that this particular development was going to halt the vetting process here. As I indicated to you early on, currently the party is vetting potential occupants of various executive positions as far as the Ashanti region is concerned. So early report that we're getting from the vetting room was that there was going to be, or the process was going to be put on hold. I mean, it continues. However, I've also cited some workers of Wontumi, and their facial expression tells one thing, that they are really down. Roland.
Individuals, particularly those associated with Chairman Wontumi, but also the MPP, even the other side of the political divide, will be shying away from commenting on this. But it's going to be a flurry of activities on the airwaves and then the public places in the Ashanti region. Based on your experience, won't it be?
Absolutely. For those who have not aligned with him as far as his understanding of the contemporary politics, and of course, that of the Ashanti region is concerned. One of the guys that I engaged think that, well, his council, he was actually blaming his council for not making an appearance at the court. And he believed that, well, he knew what was coming. Maybe it was one of those legal tactics to avoid a blame that perhaps he did not play his role well. That is his view. But I can tell you that, yes, indeed, I mean, there are a good number of them, in as much as there are people who support him, there are also a good number of them who also did not align with his way of managing the party in the Ashanti region. But yes, I mean, the coming days are very pregnant. We're still hoping to get some views just to affirm what their position is as far as the current development from the High Court in respect of Chairman Wontumi and its issue with illegal mining is concerned. Roland.
All right, William Evans Nkom, thank you for the latest updates. The Ashanti region is where our bureau chief currently is stationed. We're live across our social media platforms, streaming there, TV3 Ghana, 3FM, and then also various subsidiaries are also streaming currently, bringing to you an extensive coverage on what the court has decided on this very case that the court started back in October 2025 and subsequently has traveled over the period, and so far we're bringing to you the latest. And
Roland, we have
Joseph,
an update. We have an update to give you. So count one, Chairman Wontumi has been slapped with a sentence of 20 years with a fine of 10,000 penalty units. So 10,000 penalty units will be 120,000 cedis, and count one, 20 years in prison. So that is it in respect of count 1. For count 6, he's been asked to pay a fine of 15,000 penalty units. So 15,000 penalty units will be 180,000 cedis. 180,000 cedis. Yes, that's the amount. 180,000 cedis is the amount that he's been slapped with in respect of that particular one. So that is the update that we have for you. Chairman Wontumi sentenced to 20 years in prison. And so that is what we can update us on in respect of that particular one. So the breaking news this hour is that the NPP's Chairman Wontumi, Ashanti Regional Chairman of the New Patriotic Party, and the founder and CEO of Akonta Mining has been found guilty for various mining offense. He's been slapped with a jail time of 20 years in prison with a fine that, if you do the computation, you are looking at somewhere in the region of almost 300,000 cedis, basically, 300,000 cedis, basically. We'll be providing a bit more updates and crossover to the court and give you the very latest with that. Roland will cross over very shortly to give you a sense of what is playing out outside the courtroom. But this is the latest that is coming from inside the courtroom at this point in time. And then within context, we had said that the range that the judge was working with was 15 to 25 years. And so the judge settled on 20 in that particular instance. Okay. And the amount, the judge had a range of 120,000 cedis to 180,000 cedis. And because there are different offenses, for one, she opted for 120,000 cedis. Again, in between, then 180,000 also for another as well. And so very shortly, we'll cross over to the court and give you the very latest. But if you're just joining us, we know that at least Chairman Wontumi, as things stands now, has a jail term hanging around his neck of at least 20 years. We'll get a bit more clarification when Lord Edwasari joins us from the court premises as well, Roland.
All right. So we're having extensive coverage. Lord Edwasari is the one giving us the bit part, but more importantly, the information from the courtroom. Outside the courthouse itself, at the precinct, is our own person, Sixtus Don Ulo, also broadcaster, legal practitioner as well. We've stationed all our men to make sure that we bring you an extensive coverage just beginning after the hour of 10 up till now. We have our man in the Ashanti region monitoring, because Ashanti region is the hub of the MPP, for which we have Chairman Wontumi, Bernard Inkwibwe-Siakon, as the chair for the opposition MPP, for which there are many interested stakeholders from his party as well as the other political parties, and then the generality of the society there. But more importantly, we also here in Accra bringing you the extensive, what the various sentencing regime is, as we have in Section 99(2) as amended for the Minerals and Minings Act, and then bringing to you what the upper limit and then the minimum of the sentence as well as the fine will be. And Joseph has brought to you what the decision of the court is. But either Lord Edwasari will be bringing to us the latest, or Sixtus Don Ulo. And Sixtus, what can you tell us? Now we know that at least for 20 years, if the appeal per what is accruing to him as a convicted person will be, then it also means that will be a long way. What so far can you monitor outside the court premises?
Well, before we come to that, I would want to engage Lord Edwasari, my colleague who was seated right in the court, and then we can go through that again. But as you can see at the background, you see that there's a lot of movement, media persons here, everybody trying to get the first bite. We are waiting for who has a voice to speak to us to step out. Once they step out, you would hear from them firsthand some of the things that are happening. And even in terms of appeal, I don't think, speaking with a legal mind, I don't think this is a judgment and a sentence that would be taken lying down by lawyers of Chairman Wontumi. Indeed, we got that inkling when they started pleading for a reduction in the sentence. That is what the lawyers call mitigation. After the sentence has been pronounced, you would have some sort of attempt from the lawyers to try to reduce the sentence for the convicted person. They are not disputing the conviction at this moment. At this moment, they are saying that, look, you have convicted our client. We don't have a problem with it yet, but kindly see to a reduction in the sentence. That is the exercise that happened after the conviction. And whilst that was happening, in fact, the demeanor on the look of the lawyer Atachia was somewhat anger and curiosity, not so happy. Lord Eduasare, how exactly do you describe that?
So, Sixtus, let me just give a bit of a throwback. You recall that the lawyer Atachia, he filed some motion indicating that he was going to travel, and as a result, he wouldn't be present. And so he sent 3 or 4 junior lawyers to come and represent them, and they made a mitigating plea. They made a mitigating plea for the sentence to be reduced.
All right. Let me cut in that. We have a leading voice of the NPP, but I'm not sure that he wants to grant us any interviews. We have he's swamped, and he actually is not in the mood to grant us that interview. So we will get back to discussing, yes, Lawyer Atachia, what happened in court.
Yes, so 4 junior lawyers were sent by Lawyer Atachia because he had sent a letter Friday that he was pleading for a deferment of the judgment against Chairman Wontumi. So essentially, the lawyers who were present, they seemed very uncomfortable with what was going on when they attempted to use that motion for the case to be tried, essentially the Supreme Court's
application.
Indeed, we have gathered that he's to the jurisdiction, and for which reason he wrote the letter for an adjournment. He indicated that he'll be back within the jurisdiction on Wednesday, and so
again, we're coming to you live from the courthouse right here in Accra. And certainly that's where we broke the news, live here on TV3, 3FM, as well as across our subsidiaries and across social media platforms where we're streaming live. Chairman Entry Boisiako, an accused and subsequently convicted in this case for a number of offenses in relation to mining activities.
He's been sentenced to 20 years in hard labor with a penalty unit of 10,000 for the 2 counts that he has been charged with. Let me just quickly run you through the charges which were preferred against Chairman Wontumi. There was count 1, which was the assignment of mineral rights. We have the Deputy Attorney General here.
We have the Deputy Attorney General. Congratulations, Deputy AG. Some would say that this is a huge victory for the department. Wouldn't you say so? I mean, this has generated a lot of public interest, and I'm sure that there are those who would be applauding you that indeed you have fought a good fight. Is that how you say it?
Let me get to the stage.
All right, the Deputy Attorney General is trying to position himself well so that at least we can get one word from him. I'm sure that is a judgment that excites the department, that at least one victory has come, but it might not just be one that the department would want to keep mute over. Definitely would have to hear from them. But as it stands now, the Deputy EG has declined the invitation to comment on the judgment that has been pronounced and the sentence that has been handed down Chairman Wontumi. So that is on the part of the prosecution, the highest ranking officer that we have seen in court, the Deputy Attorney General. We are still scouting around to see if we would find somebody on the defense side so that we can have that conversation with them as well. There are questions that we'll be asking. Well, this has happened. Sentence has been handed down. What is the strategy going forward? Are they going to be appealing? What are they looking at? Appealing for what exactly? Against the conviction or against the sentence or against both? We are going to be asking them all of these questions to try to understand what the thinking is at this moment. Because earlier in court, we know that lawyers had, pleaded with the court, told the court that, look, this man, he's a very enterprising man. He has set up so many businesses. He has employed so many people. Imagine what happens to him if you lock him away for 20 years. The businesses may collapse. People may lose jobs in an era that we are asking for more jobs to be created, for more people to be employed. Again, the lawyers said that, look, he has listened to all the concerns that the people have raised. He has listened to all the concerns that the people have raised. He's followed the public discussion. He's remorseful about what has happened. And so let us, as they say, temper justice with mercy, or is it mercy with justice? It is another attempt that the lawyers made to try to get the court to reduce the sentence at this moment. But did that really happen, Lord Edu Asari?
Sixes, indeed. If you listen to what the presiding judge was making before making her pronouncement, for example, the lawyers made the plea that, well, this is his first time. He and his company, they've been involved in something like that, and so part of their mitigating plea, they wanted a reduced sentence, for example. So in her judgment, she indicated that yes, they are first-time offenders, and so and we know that the range is from 15 to 25, but he got 20 years from the sentence. Now, something that we need to talk about also is the posturing of Wontumi.
Yes. I was coming I was going to get to that. Ask you about what exactly his demeanor was. I cannot imagine how a man will look or feel the moment he is told that he is to be in jail, in prison, for 20 good years.
Hard labor.
Hard labor. That is attached.
Yeah, 60. So initially, once the sentence and when the reading started, he was intermittently smiling wryly. Some of the times when the judge makes certain statements, you see him visibly angry. So sometimes even the prosecution trying to imply that that is not the case, and so he was visibly disagreeing with some of the things that the judge was making. But getting to the latter part, then you realize that he was moving a lot within the witness box, and his face had become shiny with a bit of sweat, and now that smile was gone. He was
fading away.
Now he was beginning to look a lot more worried, and by the time the entire sentence was given, he looked like a man who has, what's the word, probably given up or didn't know what his face was going to be. And so at that point it was a mixture of sadness, anger, among other things. So Six is basically that is what we've been witnessing from the Circuit Criminal Court 4 of the Accra High Court here, where Wontumi has been sentenced.
Well, that is exactly the kind of feeling that you would expect a man to have going through such a conviction. It's not a small thing to go through, and so we want to try to pick some interviews here.
That the court should give him the barest minimum. It was not against his conviction, so it is not as if I did that to probably encourage illegal man. No, it was just for the courts to understand that Mr. Wontumi is just not like you and myself. He owns a lot of businesses. So the court, I don't know if she considered that, but well, I'm sure his lawyers would advise him accordingly.
So
please allow me to go.
Bernard Oredu.
Please.
That is Bernard Oredu.
Please, cancel.
Well, you caught the tail end of that interview with Bernard Oredu, lawyer for member of the gentlemen. Settle down, gentlemen. Settle down. You were in court.
Yes, I said.
You followed the entire process, and I'm sure that some would say justice has been done. Others would say justice has not been done. Let's start from there.
Justice is relative. I mean,
yes,
as to whether justice has been done or not, it's relative. It's relative. For me, the court has given its decision. Has left with Mr. Wontumi's lawyers to decide as to what to do next. The only thing I did in court was to plead for Mr. Wontumi in terms of the sentencing. And it is not because it's Mr. Wontumi. It's a very ordinary thing we all do in court, where if you believe that as a friend of the court, you need to put in 1 or 2 for an accused person, we do it. And we do it not because we don't believe in the sentencing, we don't believe in the conviction, or we have issues with the conviction. As for the conviction, yes, it was all done, but it was the sentencing. So you remember what I said was that since the court itself has established that Mr. Wontumi is the directing minds for most of his businesses, so it means that if the court keeps him in incarceration for long, his businesses are going to be affected. So the court should consider the fact that he's a businessman and he employs a lot of people directly and indirectly. So it was to the youth unemployment that could come as a result of his being away from his businesses. That was the only thing. I was just appealing to the mind of the judge.
Are you in any way related to Mr. Wontumi?
No, I am not.
Do you have any business dealing with Mr. Wontumi?
My name is Bernard, so probably just by name, but I have no business with him. I had just come to court to listen, but I was just moved.
So this was just an officer of the court doing the job?
It is pure out of courtroom practice, where any person could get up as a friend of the court and put in some words in mitigation for an accused person who has been convicted. So it's not because I have any personal relationship with Samreboi, and I'm not his lawyer on record. It was just out of normal court practice I did that.
That so you rose to your feet to try to
appeal to the emotions and the conscience of the judge. To just tamper justice with me. So I was hoping for the barest minimum of punishment.
But what do you think? What do you think going forward? Should the lawyers go on appeal on this matter? What would that barest minimum be for you?
What I think don't matter now, because I'm not a lawyer on record for Mr. Wontumi. I only did what a lot of lawyers do in court, that we try to intervene for an accused person who has been convicted. That is what I did.
So what is the barest minimum
the law? As to what I expected the court to do, it is by law 15 years. So if the judge had given him the minimum, I would have been happy. But for all those things we had said, maybe he was going to get something. I don't know. I'm not in the mind of the judge, I feel that what we did, myself and the other lawyer, is very ordinary in the ways courts handle matters. So please let me.
Thank you so much. So you heard the voice of a lawyer who, this is what the lawyers will call an amicus. He rose to his feet after, as a friend of the court, in an attempt to get the court to reduce the sentence. And we heard from him, he has no ties to this man whatsoever, no business dealings with Chairman Wontumi, no political connection. He's just a lawyer who was in court, who saw the processes and felt that the judge could have done something a bit lower than the 20 years that have been handed down to Chairman Wontumi. That is his motivation. That is his inspiration. That is the reason he decided to rise to his feet and to ask the court to do something about this. Hello? And so, yes, we are still here at the High Court complex here on the High Street to try to understand what really went on in court and then what we can do. We will try to get some more interviews. We will try to get some more interviews to try. Really, the thinking is going forward and what can happen. But here, it's you don't find people who are sympathizers and all, and so it's difficult to try to gauge the minds of the people who have a direct interest in this one. But we will try to engage some more lawyers to see what really What do we do going from here? Better rephrase. What does Chairman Wontumi do going from here? Council, do I have your permission to engage you? And you have been part of the process. Yes, you have followed the process from day one. You are in the thinking of the defense from day one. Is this what was expected?
Certainly not. We are extremely disappointed in the outcome. In as much as we respect the decision of the court, we have our resentment to the outcome of the trial so far. And indeed, I must say that...
You said the outcome of?
The outcome of the trial.
Okay.
Having culminated into a conviction and sentencing. Because under normal circumstances, one would have thought that at least once a person is charged with assignment of mineral right without authorization, it was right that the Lands Act clearly defines what assignment is. An assignment is by way of a written instrument. And if there was none throughout the trial, and that a person could be convicted and sentenced on same, then it's really a worrying trend. And what can we do except to consult our clients and fashion out the way forward and come out?
But the charges were brought under the Mining Act, right?
Yes, certainly it was brought under the Mining Act. But the Mining Act doesn't talk of assignment. It talks in terms of assignment. The specific legislation that regulates the conduct of land transactions is the Lands Act of 2020. Yes, Act 1036. It regulates the conduct of land transactions. So if you want to really understand what assignment means as far as land transactions are concerned, then you have to go to the Lands Act. And clearly the Lands Act talks of assignment to be a written instrument, but we did not see same. And instead, clearly, once he has been convicted on assignment without mineral rights authorization, it's clearly mind-boggling, and I am not comfortable with the set.
You describe this as mind-boggling. Yes, to you, it is unfair. But let's talk about the processes of the trial itself. Would you say due process was followed?
I will reserve some for.
Would you say the judge was fair throughout the proceeding?
I wouldn't want to, with the circumstance I find myself now, I don't want to comment on some of the matters, but I believe that as a legal team of Mr. Benedict Bosiako will come out with his tact endorsement to speak on some of the matters that has gone on throughout the trial.
And that response points directly of an appeal. Is that what I'm sensing?
Oh, certainly. Once you are aggrieved or dissatisfied by the outcome of the decision of the court, the onus lie on you to file an appeal at the appellate court. Now, from the High Court, you can only go to the Court of Appeal. Satisfied, the rules of courts and the laws of the Republic allows you to go.
In breaking news coming into our studios here at TV3, Chairman Wontumi Bernard Enchibwesia, as he's formerly known as, has been convicted of a number of offenses.
Absolutely.
And now he gets some 20 years in jail, setting precedents as being the first high-profile case to have gone through the entire trial period and be sentenced as well. But there's more to how we got here.
Absolutely, and there's been a lot of discussions, lots of conversations. I think in the initial stages as well, we've been told 6 counts, convicted on all 6 counts, 20 years, 10,000 penalty units as well. What are these counts and what are we looking at is what we're seeking to get a bit more in terms of details on for you this afternoon here on the bulletin. And I'm just going to walk you through what the particulars of the offense are, right? And then it will set the tone nicely for us to begin to appreciate amongst many other things.
Very well.
What it is that we're seeing.
We'll give you time. We'll give you time, Mawena, to work on that. But we know that Chairman Wontumi was convicted of assigning mineral rights without approval and purposely facilitating illegal mining at a Samreboi concession. But Mawena will take us through the rest of the offences in a tad, because there are about 6 of them. The court found him guilty of all 6. And he's been handed down 20 years in prison with hard labor. That's the latest that's coming on this matter. But what were his offences in this landmark case? Mawena, what do we know?
And so 6 counts, and there are 3 individuals involved in this particular matter. A number of persons have been asking questions, and I've been seeing people drawing linkages to other cases currently in court.
Right.
This is the Samreboi case involving Wontumi, which has to do with assigning mining rights to another person without approval by the minister. And on the first count, assignment of mineral rights without approval, contrary to sections 14(1) of, just a moment, a bit of a trick there, but a bit better, right? So, just a moment.
Oh,
so
what a shame.
To section 14(1) and section 99(2)(b) of the Minerals and Mining Act 2006, Act 703, as amended by section 3 of the Minerals and Mining Amendment Act. That is the first count, and that is against Bernard Nchibu-Esiaku, who is one of the directors of Akonta Mining Company. Then there is the second count, right? That has to do with Kwame Entry, who's at large as we speak.
Right.
The third count, just a moment. And so we get to see
So I mean, essentially what you're trying to show us is that there are 3 accused persons here. Chairman Wontumi, one other person called Kwame Entry, and then the company.
And then the company.
Right. And Chairman Wontumi has been convicted of counts
1 and 4.
And 4, right.
Counts 1 and 4, because count 1 directly to him, and then count 4 as well, purposely facilitating an unlicensed mining operation contrary to section 99(2)(b) of the Minerals and Mining Act as amended by section 3. So count 4 as well. Then we see count 5 going to Kwame Entry as well, who's still at large, and then count 6 as well to the mining company. But as company is deemed as a separate legal entity, and so it also is before court. But on counts 1 and then 4, which speaks directly to the person, Bernard Nchibu-Esiaku, we're seeing that 20 years for both counts, 10,000 penalty units for both counts as well, and it's expected to run concurrently as we speak at this particular point in time. And so we see counts.
This is count 2.
This is count 2. Kwame Entry at large, that you in the year 2024 in Samreboi in the Western region and within the jurisdiction of the court, blah, 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 and blah, permitted mining without approval from the minister. And so that is count 2. And then we see counts 3 in relation to Akonta Mining Company as well, and all of that. So 6 counts, 2 each for Wontumi, Kwame Entry, and then Akonta Mining Company. It's just a shame that we've not really been able to go through all of the entire detail. But you see count 6 there, for instance, which deals specifically with Akonta Mining. We see count 5, Kwame Entry, like I was mentioning again, also dealing with facilitating an unlicensed mining operation contrary to section 99(2)(b) of the Minerals and Mining Act 2006. And this is where we are at this particular point in time. And we've been hearing, we've been seeking to get a bit more in terms of reactions as well. I'm sure we'll go back to the court for our man, Lord Eduasare, to paint a mood for us as well, because there's been a lot said, what the court looked like, what his mood was like when the judge began detailing the count one after the other and was arriving at the guilty conclusion, amongst other things, what he made of it before he was subsequently whisked away by officials of the security service after the court's hearing as well.
Right. I want us to go back to count 1, which is directly related to Chairman Wontumi, because that is when they say he assigned mineral rights without approval, and he was found beyond reasonable doubt that no ministerial permit was obtained, for which reason he was convicted on that as well. And on count 3, Akonta Mining, the company, as you've explained, was also convicted. Of the offense there as well. But let's stay on count 1, right? Because Moena, that is where the bulk of the issue is. How Chairman Wontumi is now getting 20 years in prison with hard labor. The judge says, look, when we go through the evidence, we see that there was no ministerial permit for that. What are we seeing on that as far as the charge sheet is concerned?
Right. So going back to that, and we'll get that for viewers pretty shortly as well. Going back to that speaks directly to his concession, right, at the Samreboi forest area.
Right.
And so he had a concession which was given unto him, which means he could go in and mine in and of himself. But he subsequently resorted to handing it over to a third party. Now, what the requirement of the law is that in proceeding to do something like that, it requires the approval of the Minister for Lands and Natural Resources. That was not done. And so our laws are a bit funny when it comes to engaging in illegal mining. So you can have permits, all right, but when you breach, you enter the realms of illegal mining. Because as far as you have permits and you're mining within 100 meters of a river body, the law is very specific. It says that even if you have a permit, don't go 100 meters to a river body. If you do that, that becomes illegal mining. And so of the many things which could stray outside of having a legal concession is having a concession and granting permits for someone to mine without the approval of the minister. That's the first count upon which he's been convicted and is to serve 20 years in hard labor with a fine of some 10,000 penalty units as well. I'm going to try and take us back to the board just a slight little bit, right? I'm going to take us back to the board just a slight little bit and see if we're able to make a bit more in terms of progress in that regard as well. And so that's count 1 for us.
So Marina, at the time, who was the Minister for Lands and Natural Resources?
That will be
one of the Jinapo
Samuel
brothers.
Jinapo.
Indeed.
Because this is in relation to 2024. And so Samuel Jinapo directly was the Minister for Lands and Natural Resources at the time.
At the time. You also recall that this issue had simmered a little bit under the NPP administration. There were responses all the way to the president, correct? We recall that the president at the time had said that they had found nothing wrong.
Absolutely.
Right.
So that is where a bit more in terms of clarity as well is needed, because that particular case, which drew that response from the president, is completely different from this. That was the Tano Nimri Forest Reserve.
Right.
And that case as well is pending in court. So this is Samreboi. In the Tano Nimri Forest Reserve, that's a claim where he didn't have a permit and invaded the forest and was mining illegally. So
very similar to this.
Yeah, you can say similar.
Permit.
No permit. No permit, right? So that is a direct allegation of mining illegally in a forest without a permit whatsoever. In this particular one, and I'll go through the first count again for you. Assignment of mineral rights without approval, contrary to section. And if you read the particulars of the offense, it reads that Bernard Nchibu alias Wontumi, that you in the year 2024 in Samreboi in the Western region and within the jurisdiction of this court, being the owner and controlling director of Akonta Mining Limited, did, without first obtaining the prior written approval of the minister, permit Henry Okum and Michael Jedu AEC to undertake a mining operation within the mining concession, which was granted to the said Akonta Mining Limited only. So, again, I was making the point. A specific license has been given to Akonta Mining Company only.
Right.
Now, if you decide to hand over that permit to another individual for mining, it requires express approval from the Minister for Lands and Natural Resources. And you see, that was in 2024. The Tanonimri Forest Reserve, which drew then President Akufo-Addo's response and saying, as at now, Wontumi was not engaged in any illegal mining. It's the Tanonimri Forest, and that matter as well is in court.
Absolutely. And, we've traveled a long way with this case, Mawena, all the way from October of 2025, when the 3 accused persons were formally charged relating to the illegal mining activities in the Samreboi area. The charges facilitating unlicensed mining and assigning mineral rights, just as you have explained. These ones particularly to do with Chairman Wontumi himself. We know that at the beginning of this year, the Accra High Court commenced hearing the criminal trial. Witnesses for both the prosecution and defense subsequently testified over several months. And then on June 3rd, 2026, the defense called its fifth and final witness, Evans Ade, officially closing its case. The High Court then fixed July 3rd, 2026 for judgment and directed both parties to file their written submissions by 17th June. Remember that within this period, then there was a change in attorney as well.
Absolutely.
Because Andy Apiakubi, who was the attorney then, who had sat through the entire case, nearing the filing of written submission.
He went to court to inform the courts that he was not going to be attorney any longer.
It took quite a dramatic turn.
They didn't need to grant approval for you to decide not to represent your client any longer, and so it was a matter between your client and yourself. And people have said that was a tact of sorts to have delayed getting to the point we are today. But then subsequently, we know that Samuel Atachia took over the case. Absolutely.
And then this is where we are today, because at deadline of June 17, 2026, prosecution and defense were to submit their final written legal arguments to the court. I'm not sure it happened on this day.
No.
It happened after this day.
Absolutely.
Because that is when Atachia took over the case. And we know that a few things have happened also since then, trying to make sure that today's ruling wouldn't have happened today because they had taken another matter to the Supreme Court.
Absolutely. And so after he took over, Atachia made a plea to the court to be granted an extension to file the closing address because he needed to acquaint himself with the processes of the court in relation to the subject matter. The judge, Justice Kokuvite, granted that request, and there was that extension. In fact, initially, judgment was to be delivered on the 3rd of July. But because of the extension, it was extended to July 13 to have them file the closing addresses for judgment to be delivered on the 20th, which is today. Now, subsequently, lawyer Atachia has filed some additional cases at the Supreme Court, seeking interpretation as to the provisions upon which Wontumi has been convicted of today. That is Section 14(1)99(2)B and some other provisions that they are too broad, too vague, and so it doesn't quite encapsulate properly in terms of legal, there's a term for it, right? It doesn't properly encapsulate an understanding properly to allow for a conviction. And so it requires a bit of interpretation. And so Justice Kokuvite should stay her hand in wanting to deliver her judgment today so they can head towards the Supreme Court for interpretation. Now, that was the application which was to be moved first off today. And then before today, we got wind of the fact that Mr. Atachia as well was not in the jurisdiction because he's had to attend to other matters outside of the country, and so was praying the court to stay its hand and adjourn briefly to allow him return and move the application to have the judge defer the delivering of the judgment and then they can't head to the Supreme Court for interpretation in relation to these provisions. But the judge declined that request today and said that it was of no consequential effect as to her decision to want to deliver the ruling, and then subsequently went ahead to deliver the ruling, which has come very big. 20 years on count 1, 20 years on count 4, 10,000 penalty units on both, and they are to run concurrently in hard labor as well. And that's what we're learning of. Well, that's what has become of the fate of Wontumi as we speak at this particular time.
We can also tell you that attempts to reach the NPP to speak to this matter have not been successful. The party says it is digesting this to come out with its a uniform response to what has happened to the Ashanti Regional Chair. You recall also that alongside this trial, or his many trials, he's also been seeking to be national chair of the NPP as well. So it's a very complex outcome for his campaign, and would like to hear from them as well along the line. But we've been to Kumasi and we've seen how people are responding to that already. That is his base. That is where he's always rallied the party support and kept it strong, despite it being the bank for the NPP. Very phenomenal person when it comes to the NPP.
Yeah.
He's not only a stalwart of the party, but he's also an on-the-ground person as far as the NPP is concerned. We've seen his action over the years as he's become, regional chair for the NPP. Region. He's also been embroiled in a number of controversies which are not worthy of mention right now. But to note that the NPP will be losing a very important person to jail at this time, I'd expect that there will be a bit of a fight when we hear from them later today on the subject matter, because this is no mean person for the party. This is the original chairman. This is Chairman Wontumi, who's not only rallying people, he's rallying funds for the party as well. And so we expect that the NPP will come out soon to talk about what is happening to them with the loss of Chairman Wontumi, how they are hoping to rally themselves behind him. Because again, this is a precedent-setting case. Have you heard of any high-profile person being found guilty?
That's been high-profile.
Of illegal mining.
So illegal mining becomes
absolutely
the
that's
area.
the separating factor. Yeah, right. I mean, so it's a precedent-setting case. It's the first of its kind in this country. The government of the day would want to, take credit for it and tell the Ghanaian people this is what we have done. Of course, we can't take that away from the government, but there is also no denying that the opposition will now come up with the political explanations of what has happened. We expect to see that over the next hour or so from the NPP. We also expect to see a very fierce fight from the party as well, because again, I won't belabor the point that Chairman Wontumi is a very important person, significant pillar of the party.
If you ask me, this is not the last we're going to be hearing of this particular matter.
Absolutely.
Because a number of legal options continue to await them in terms of a recourse to what has happened. Off the top of my head, the expectation is that as lawyers will be seeking to appeal this decision.
Absolutely.
We'll be filing a stay on the court's order and hopefully try and prevent him from ending up in prison to start off with while they appeal the decision of the court. I'm sure the Attorney General will have a different opinion as to that as well in terms of everything that's to happen. But most certain, this is not the last we're hearing of this particular matter. On the other side, questions will be asked as to what this means generally as well in terms of the fight against galamsey.
Illegal mining.
Right? Because this is a high-profile individual for that matter. In fact, if you go on to civil society groups, they've been very frontal, talk of eco-conscious citizens, the Media Coalition Against Illegal Mining, you call it what? Arocha Ghana, they've been very vociferous, frontal, asking that go after the big individuals who are sponsoring activities of illegal mining and stop arresting the young persons who are looking for their daily bread. This is one of such big convictions. And no mean person than the Ashanti Regional Chair, who actually many have tipped could, if this delayed a bit longer, could have been a swell point for him to have risen to the position of national chairman.
Chair of the
As to whether or not that will be the case, it remains to be seen now that a conviction has come through. But all of this put together suggests that it's a big name.
Big name.
How do you ride on this going forward? Are we to see even more in terms of the fight against Galamsey? Because when all is said and done, it comes back to that singular argument, singular statement, illegal mining, and what ought to happen in terms of what the government says will be an unrelenting fight against activities of illegal mining in the country. And so it will come to that. And I'm sure we will get to speak as well to a number of the civil society groupings as well. But we're going to take you to so Awola Sewa is joining us. She is she's with Eco-Conscious Citizens. She's a legal practitioner as well, and so she's joining us via the phone lines right now. Awola, thank you very much for speaking to us this afternoon. For you in civil society, what do you make of the court's decision this morning?
Well, the decision is welcome because, as you know, journalists, including Erasmus Asaidem and others, have put their lives on the line to know persons who are involved, who are allegedly involved in ecocide, poisoning our water bodies and destroying our forest reserves. And you might recall that the case of Akonta mining, it was brought to the notice of the then president, and even by the Catholic Bishops' Conference. And there was the response from the president that he was not involved in mining. But the court thinks otherwise, and we are pleased with the outcome. All we say is that there should be the polluter pays principle. So anybody who is convicted of illegal mining, their assets should be sold and used towards the cost of reclamation, which is a very, very expensive business. So much as we are pleased, what we are saying is that other persons were named in Professor Frimpong Boateng's report. Also, under this administration, what you call politically exposed persons, kingpins, have been named. It is astonishing that there have been no prosecutions. Because what we are saying is that everybody who is involved in the poisoning of Ghanaians and the destruction of our landscape should be held accountable, whether you are a small fry or a kingpin. And unfortunately, apart from Chairman Wontumi, we haven't seen any other high flyer being prosecuted, which in our view is worrying.
So 20 years, 10,000 penalty units, you say his assets should be sold to as well enable in reclamation?
What we are saying is that we should have the polluter pays principle. So anybody who is convicted of polluting our environment, our water bodies, it's not sufficient that maybe you serve a jail sentence. That is not sufficient. Your assets should be sold and used towards the cost of reclamation to send a very clear message. And not only will you be sent to jail, but any ill-gotten wealth will also be sold and used towards the cost of trying to repair the damage that has been caused. This is to add to the deterrent principle, because you cannot just pollute the environment and serve a prison sentence. We need to do some reclamation, which is very expensive. Who is going to pay for it? The taxpayer?
Now, what does this say, this ruling? What does it say in terms of the general fight against illegal mining? Because for a very long time, yourself and a host of others have asked that, look, the big names, the big individuals sponsoring what you've described as environmental terror be frontal in terms of prosecutions. Now we've got one, if we can call it that. Your expectation going forward, and then the fight against Galamsey as well?
Expectation is that this is not the beginning and the end. Chairman Wontumi is not the only high flyer involved in illegal mining. There are so many others under the past administration and also under this administration. That's why the fight doesn't seem to be going anywhere. So that I want to add here that we are pleased that the Attorney General dropped the charges against the Atronso 5, who were activists protecting their landscape and the Nana Atronso stream, who eventually were being prosecuted. Thank God that sanity has prevailed and the charges against them have been dropped so that we can focus our energies on going against those who are destroying our environment. And so it's a step in the right direction that Wontumi has been convicted. It's not enough. All the other highs who have been named should also be prosecuted, even as we are prosecuting the ordinary Kojos and Kwames who are involved, because everybody who is involved should be held accountable from the low to the highest. Everybody should be held accountable. That is unacceptable that we are actually prosecuting the Kojos and Kwames, but those who are financing this evil setup are not being prosecuted, with the exception of Chairman Wontumi.
While we are at this, the government has attempted a review of legislation surrounding mining as well, because when all of this is said and done, it comes back to how well we're protecting the environment and how well mining is responsible as well. If you look at the entire architecture, considering as well reforms to legislature, are we beginning to stem the tide, or turn the tide rather, against activities of environmental degradation and the devastation of our forest reserves?
The only thing that will stem the tide is if we are robust with enforcement. You can go and pass any legislation you like. We didn't need any new legislation to prosecute Chairman Wontumi. As we speak, the current legislation is sufficient to prosecute those who are committing sacrifice. What is lacking is the political will. What is lacking is the appetite to do the right thing. His Excellency the President was lamenting about how persons in his administration or party quit themselves. It is not sufficient to lament. What needs to be done is that those who are involved, and none of them have been named, they should be arrested and prosecuted. Let me say this here. You have Gemma in the Iowa municipality. They have a beautiful rainforest and a pure pristine water body. There's no illegal mining going on there. Why? Because the chief, Nana Eneko, are not the second, and Father JB, a formidable community champion, has set up Jaga, Gemma Anti-Galamsey Advocacy, and they have patrols. Every so often they arrest illegal miners. Whether the police decide to release them or not, at least they arrest them and stop them from causing mayhem. If Gemma can do it, why can it not be replicated? Why cannot it be replicated? In any locality, if the chief, the political authority, and the police command say that we're going to clamp down on illegal mining, it's not going to be successful illegal mining. But when the chiefs are complicit, the political authority is complicit, and the police command is looking the other way, illegal mining will thrive. So I'm saying a challenge that if we follow the example of Gemma and we start holding chiefs accountable, the political authority accountable, the police command accountable, we will see a reduction in illegal mining. As it is, it's going on because there's no political will to deal with them.
Right, we'll leave it here. I'm sure there'll be a bit more subsequently, but I appreciate you joining us. That's Awula Sewa. She's the Executive Director of Eco-Conscious Citizens, speaking to us this afternoon on the latest, right, as we're learning of. But we're going to subject this to a bit more in terms of analysis right now, Kemini, and you're going to go over the Zoom right now and engage a bit more in terms of persons.
Well, if you just joined us, this is our continuing coverage of the conviction and subsequent sentencing of Chairman Wontumi, known by his government name Bernard Entry Buesiakon, to 2 20-year terms in prison to run concurrently in hard labor, 10,000 penalty units as well. But let's have a conversation on the back of this, as Maureen has already indicated. Private legal practitioner Martin Kpebu is joining us on the subject matter. Martin, sound decision by the High Court?
Decision, yes, it is. It's a sound decision, without doubt. I was in there, at least I listened to the judge for at least altogether at least 1 hour Yeah, I was in there for more than 1 hour, but I had to go do my other cases. What I heard was very sound. Kudos to Justice Kokuvite. I'm sure she'll be one of the next candidates to go to the Court of Appeal. She's been in the High Court for long. So we hope President Mahama will look favorably on her and send her to the Court of Appeal. She's done a good job. Look, it takes bravery, eh? It takes a lot of bravery to render this decision. We don't, so we should, look at what can be done to also show the judge appreciation. Not everybody can give such a decision because when you go, sitting in court there and say, hey, is that the Ashanti regional minister? Listen, you see, I'm even saying minister. You see, Chairman Wontumi at a point, they were calling him what? He said he was the governor. No, there was a minister. He said he was the Ashanti governor. And you know what that meant. You see, so on the ground, he wielded a lot of power. And yet here, today, he was in the dock and Justice Audrey Kokuvite was reading the judgment. Then I felt that, oh yes, Ghana is working again. Ghana is working again because this is the same kind of case that where under Kufuor administration, we presented our petitions against Chairman Wontumi as far back as October 2022. 2022, more than 2 years before Kufuor left office. Yeah, the CID boss at that time, and Kofi, and then IGP, they were doing kukwasa, like, so to wait, delay, because of Chairman Wuntumi's influence. So you see why we had to change the MPP so that the system would work. Because as long as MPP remained in power, Chairman Wontumi was not going to be brought to book because he was governor of the Ashanti region, governor. And today he's been showing his real size, right? Yeah, so it's good. It's a good judgment by all standards. But in the legal system, you can expect that he's going to go on appeal, etc.
Absolutely. What do you say to those who think that the judge, Kokuvite, should have waited for the Supreme Court interpretation that Samuel Atachia was seeking or on the minerals aspect of the Minerals Act that was being used in this case?
Well, that would have taken the case too long. It would have taken too long. We don't know when the Supreme Court will do the interpretation. So that was way too long. Even the first question is, as to whether the Supreme Court would even accept to do the interpretation, nobody can tell. You see, when you do a reference, what Atachian's request is that send it to the Supreme Court that this and this and this require interpretation. Now, as to whether the Supreme Court will agree, we will not even know. So it's not something like Justice Kokuvite could take it to the Supreme Court, let's say a week. And don't forget, 31st of July, next week, Friday. That's our last day. We are going on vacation. So from 1st August to about 10th October, these kind of cases, the type that involve giving judgment in criminal cases, people giving evidence, Supreme Court sitting, cannot happen. So the Supreme Court doesn't sit from 1st August to at that time in October. As I said, let's just say practically by somewhere around 10th October, the Supreme Court would not work. Remember that even the year we're clamoring that the Supreme Court should work during the vacation to take care of this Daniel Yao Domlevo case, where we thought that Ekufuor had sacked him because they didn't want Domlevo to catch them stealing. Even that one, the Supreme Court didn't sit. The Supreme Court didn't sit.
Right.
Much less at this one. So what I'm saying is that the timelines simply didn't favor Atachia's request. The timelines didn't favor. In any event, and the judge also said that she has done her own interpretations. So what will happen is that now that the decision has been rendered, by all means, they will disagree. So they can file an appeal, and then they can file for appeal, pending for bail. They can also file for bail. They can
right. So Martin, what I'm trying to understand is, I mean, a number of times we've heard that, the wheels of justice grind slowly. And I hear you make the case on timing and the fact that the Supreme Court's interpretation could take a really long time. What would we rather have? That we have this done well and done right, or we rush in getting to a decision as we, as it may be, it may not be the case, which is why I'm asking, right? Was it a legally correct step that the judge had taken in this case?
Yes, on the facts of this case, yes. So I'm very mindful of that policy. Yes, even the courts also adhere to it. That's why justice grinds slowly. That we would rather take our time and do it right than to rush and to abuse somebody's human rights, etc. Yes, that's not lost on the court. And almost every lawyer who means well for this country, we invoke it all the time. But on the facts of this case, I don't think much injustice has been done. You see, when you listen to the judgment, the evidence so far, Wontumi doesn't deny, right? It doesn't deny that he gave the land. But he is saying he gave the land as a concession to this Henry Okum and JC Apia to do reclamation. So let's go to the facts. So in order to determine whether there is danger of abuse to his rights, you look at what really happened. What really happened is that the forest has been degraded, forest destroyed in mining operations. And what's the response? Then Wontumi says, oh, I only gave it to him to do reclamation. But the person you gave it to says, no, I did mining on it. Mining. So the one who was in the center of it, the one who undertook the illegal mining, is saying that no, you gave it to me to do mining. So it's mining I've done and destroyed the forest. And Wontumi said, no, I only asked you to come and cover up. That's do reclamation. But you know where Wontumi's case falls apart, as shown in the analysis of Justice Kokuvite.
Very well. And just a quick tracking back of what we have discussed already. I've just been told that there is no case yet at the Supreme Court. Rather, Samuel Atachia, who's counsel for Chairman Wontumi, had indicated an interest to do so, or a desire to do so. So, Martin, I guess that we are back to the point that indeed it was a sound legal decision that was taken, and no legal misstep had been taken in this process at all. But looking ahead, you've talked about how there could be other options for them post this decision. What could be there for Chairman Wontumi after this decision?
Good. Now let's correct. Maybe the way the person didn't hear well. So let's correct what's happening. Atachia brought an application, to the court that there is Justice Kokuvite should send the matter to the Supreme Court, Senate. Nobody has said that there's a matter before the Supreme Court. So let's say maybe the person didn't hear well or he doesn't understand.
Oh,
so
that was not for you. That was for me. Because I had asked the question on the premise that the matter was already at the Supreme Court. So I was running it back to correct my question.
But I didn't answer it on the basis that the question, the case was in the Supreme Court. No, the motion is before the judge in the High Court. So he is requesting the judge. And the judge has to look and see whether, in actual fact, it should be sent. So Justice Kokuvite, in reading through, dismissed it. I said, no, I'm not sending it. The matters you've raised, I'm not sending it. So then I was also asking that even when it's sent, it takes a long time. They don't deal with that immediately. So we're just further explaining. Okay. Yes. So now to your new question. Yeah.
Right. So I'm asking, what are the options now post the sentencing?
Yeah. So a notice of appeal, and then he will be asking for bail pending appeal. Yes, the laws allow it. And that's why earlier on I said if you can demonstrate that the judge got it very wrong, then that is where he can get bail. But if he doesn't demonstrate that, he will continue to serve the sentence. Another option, which I see may well help him and which will support some time in the future, is when he asks for a rate, not in JM's administration, the next NDC administration, because 20 years by our laws, when they give you any term of imprisonment, generally, I'm doing the general rule so that there's no time for the exceptions. The general rule, you serve 2/3. So in this case, you do 20 divided by 3, and then you throw away 1/3. The remaining 2/3 is what you serve. So in this case, if you're doing 20 divided by 3, I think somewhere it will be 6 point something. Now, so you throw away one of the 6. So now he'll be doing a little above 13 years.
Right.
So above 13 years, that's what he should serve. Now, out of this 13 is still very long. So I support a case where maybe by 7 years, if it's any time between 5 and 7 years, if it's granted a pardon with the extra request that he should properly reclaim, apart from the penalty the judge has imposed, if you make available money for this proper reclamation, yes, between 5 and 7 years, if he's this granted a pardon, it's fine. It's fine.
And over this period, we know that he's facing additional cases as well. But Martin, we'll leave it here. Thank you so much for talking to us. Martin Kpebu is a private legal practitioner. We've just been discussing that breaking news we have been covering over the last hour or so here on TV3 about the sentencing of Chairman Wontumi, the NPP's Ashanti Regional Chair, to 2 20-year terms in prison and about 10,000 penalty units as well, Moena?
10,000 penalty units for each of the counts. So count 1 and then count 4 as well, as we've been making viewers aware of. I'm going to take us to Ashanti region pretty quickly because as we've been speaking, we've mentioned repeatedly that that's the hub, the home, right, of Bernard Ntwi and the heartbeat of the NPP, right? Evans Inkum is at the Hatsa Lodge, where a number of persons affiliated to the NPP and what have you have gathered, and we're going to get a bit more in terms of details from him as well. Evans, appreciate that you've joined us and you've been with us all through. For now, the details have simmered a bit. People are becoming more and more aware as to what has happened to the Ashanti Regional Chair of the NPP. Talk to us as to immediate reactions from persons in and around and within the party as well who've been speaking to you, even if behind the scenes.
A lot of discussions are happening here at the Hasta Lodge, where potential executives of the regional base of the NPP are being vetted. And I can tell you that the process has been impacted by the verdicts. Initially, this place looks very lively. That is before the verdict was being delivered or was to be delivered. This particular place looked very lively. But just after the delivery of judgment, the whole atmosphere changed. And I can tell you, a good number of them have left already. The kind of mood that I witnessed when I first came here has changed drastically. But I've been speaking with some members of the party, particularly an aspiring regional communication officer of the party, who has also remained a member of the communication team and also a member of the professional group of the opposition New Patriotic Party, Ishak Gobe, and he has been sharing his thoughts as far as judgment is concerned.
Evans, we'll hear from him pretty shortly as well in terms of, but this Hatsa Lodge, what is its significance with the NPP? Why that place for the party bigwigs as well to gather as they listened in and we're getting details from the courts today?
Well, for some years now, this is where they've been having the vetting, that is vetting of parliamentary candidates and that of regional regional executives as far as the NPP is concerned. It has been a safe haven for them when it comes to vetting, maybe because of its location. A quiet place, very conducive, and so they are able to have a successful exercise when it comes to vetting. And that is why it has become part of them as far as their internal or intra-party politics is concerned. Mawena.
Right, Evans, let's listen to the communications officer of the NPP in the region who you've been speaking to now.
Madam, I'm not a lawyer, but as a layperson,
my view is that 20 years is a lot of years. That's a gentleman who just turned 50. And if he's going to spend the next 20 years in jail, well, that will be somewhere after his 70th birthday. And therefore, it's a moment of sadness for the New Patriotic Party, and in particular for the MPP Ashanti. Chairman Wontumi, for me, in terms of service to the party, although from a university campus, has always invited me when there are issues about elections, issues about research, and any other matter that he deems fit. I would say I am either the first or one of the few that will be invited to come and assist him at the regional party level. Somebody that we have worked closely with, and therefore, whether you love him or hate him.
Thank you for those details. I'm sure all throughout today we'll get a bit more in terms of reaction from the people, the general populace outside of the membership, direct membership of the NPP as well, what they make of this ruling, because we know Wontumi is a big name in the Ashanti region as well. We'll connect with you again shortly. Evans, thank you very much. Kems, I'm going to just come back to you because we'll have to go back to the court to catch a bit more in terms of details as well.
You're absolutely right about him being a big name. We'll talk about that in a tad. But right now, let's head back to the courts. This is our continuing coverage of the conviction and sentencing of the NPP's Ashanti Regional Chairman Wontumi to 2 20-year terms and 10,000 penalty units for each of the 6 offences he was charged with. Sixtus Don Ulu is joining us from the courts where he's picking reactions from people who were gathered there. There's new information, Sixtus, are here. Well, Sixtus, we understand you have new information on how this case is evolving since the last 2 hours or so it broke.
That is rightly so. We have been trying to understand what exactly went into the sentence that we have seen handed down to Chairman Wontumi. We have had a discussion. You have gone through the particular charges, the counts, and all of that with Mawina. You had that thorough discussion. But why did the judge convict and sentence the way she did? Is the question that we have been trying to find answers to. And I'm sure that the moment we get the full judgment of the court, we would be able to see that. In the interim, we have been gleaning through some of the comments that the leadership passed in response to the mitigation that lawyers attempted pleading on behalf of Chairman Wontumi after the conviction. We know, and earlier we had an interview with one of the lawyers, Bernard Owusu Donko, who is a lawyer, was in court upon the conviction. He rose to his feet as a friend of the court and attempted, reasoning with the court to, as we say in our everyday parlance, to temper justice with mercy. We know that lawyers for Chairman Wontumi himself or themselves have also tried. They tried getting the court to give a much more lenient sentencing. But the court, upon listening to all of them, made some significant pronouncements. And I'm sure that we are likely going to see the same thing in the judgment. Once we see the written judgment, we are going to see some of those things there. Now, the judge said that the matter before the court is one of national interest, that the gravity of the offense is such that we need to be able to serve a warning to people, to others, not to engage in similar offense. that we cannot take for granted that maybe based on this sentence that would be, or the proceedings that have already happened, some other people would not do so or are not already even in it. And so the offense is grave, and the sentence has to be deterring enough to keep others out of operations. That is one of the reasons that the court gave. The other reason that is given is that the minerals are the property of the state. I mean, if you go through our constitution, you would find this, that the president holds in trust for the people. And so the court notes that the minerals are the property of the state, and the illegal exploration of such minerals should not be countenanced. That something that is meant to be the shared property of every single citizen should not be taken over by one individual. And that is the second reason that we have seen. And the court said that it also has taken note of the fact that the first and third accused persons, the first and second accused persons are first-time offenders. And so that even that was taken into consideration in the pronouncement of the sentence. So it's left some to ask, if they were not first-time offenders, could we have seen a more, should I say, serious sentence? Is a question that some are asking as we speak. But also be minded that the sentencing is not in vacuum. It is guided by law, and the judge does not have the luxury of going outside. But as it stands now, we know that the court intends for the sentence of Chairman Wontumi to be a deterrent to all other persons who are mining illegally, who have obtained concessions without going through due process, who are on the land degrading the land, all other persons who are taking mineral resources from the environment without the needed approval, permits and licenses from the appropriate authorities and bodies. This is the reasoning of the court. But like I said, we will get to know more once we read the judgment in full.
Sixtus, thank you for bringing us that. Sixtus Don Ulu joined us from the Accra High Court with the reasons on the judge's decision so far. We are getting to learn that the judge made considerations, Mawina, which is why Chairman Wontumi and the second accused person did not get the maximum term.
I think the maximum is 25.
25 years, a minimum of 15 and maximum of 25. And now Sixtus has just run us through the judge's considerations that she made before that decision to hand him a 20-year term, 5 years short of the maximum. And, you know, it includes the fact that he's a first-time offender in the eyes of the law, so to speak, in the eyes of the law. But we are getting a bit more on this.
Absolutely. Let's speak to former counsel, right? Former counsel of Chairman Wontumi, Bernard Ntriboisiako, Andy Apiakubi, who's joining us on the phone lines right now. Counsel, appreciate you for speaking to us this afternoon. Any surprises, the conclusions arrived at by the court, considering you were neck deep in this until it was time for written submissions?
Surprise is an understatement. I am exhausted. I don't even have any words to bring out. In fact, I am so disappointed with our criminal justice system as shown by this court. I am so disappointed.
Right.
Because this judgment is premised on two charges. One of them is assignment of a mineral rights without authorization from the minister responsible. Number two, facilitating the mining or supporting or providing support services to a miner. And in both cases, I think that the evidence on record could not support the charge. In this state, my position in criminal law, I do not hold brief for anybody who will flout the law. And in the case that somebody has committed an offense and there is evidence to support it, I will not in any way obstruct the process.
Right.
As long as the criminal process is.
Counsel, on the subject matter of... Yes, can you hear me, please?
As long as the due process is followed.
Right.
Again, I am of the opinion that before you can convict, you need to rely on cogent evidence. And in this particular case,
Counsel Apiakubi, we are struggling to hear you a bit. If you could kindly reposition for us so that your submissions can come through. But you've raised two very important points, that you believe, amongst many other things, that the two charges upon which Mr. Wontumi was convicted, you disagree with. I know very well that in the course of this trial, you raised a submission of no case, simply to argue that the prosecution had not advanced enough evidence to warrant you opening a defense, and that there was nothing had been proven beyond reasonable doubts that Mr. Wontumi had committed the offenses he's been accused of. The judge disagreed with you. And so if you say there was no basis upon which a conclusion was drawn to arrive at this decision, some will look at the court's processes and say, you were there, the court pointed you to why they believed there was a case for you to answer, and you proceeded to open your defense.
Yes, indeed, I did not agree with that decision, and therefore we filed an appeal against that decision. And to tell you, in March, we filed this appeal. As we speak now, the court has not been able to mobilize the evidence or the records to the court of appeal. As we speak, this is 4 months down the line. And I've been to the registry of the courts many times. And the information I'm getting from there is that they cannot lay hands on the docket to be able to prepare the records. I've even filed March. We are still here. We have not even settled records. So, how procedure have we become? I have agreed to the decision that we had a case to answer. No, I did not. And I filed an appeal. And the appeal has not been heard, even up till now. And as I'm telling you, the records have not been accepted. We have not been accepted any of the records. And right. We cannot go on appeal when the records have not been transmitted to the court of appeal.
Right.
Why are we waiting for just records to be settled? And number two, as we disagree with the fact that there is a case for us to answer, we also do not also ask the fact that those who were charged with Chairman Wontumi gave their statement. And the caution statement that they gave contradicts the witness statement that they filed subsequent. The same person they rely on as a witness who would have said that apart from claiming the land and planting coconut trees, he also told me to do some mining. It is coming through him alone and no corroborating evidence. And this person who is saying that in a witness statement had earlier given a statement saying that I did not do any mining. And we will rely on this evidence to convict somebody for 20 years. We are in Ghana.
Mr. Apiakubi,
circumstances that I have enumerated to you suggest that there has been an attempt to take him by all means, because the witnesses who came to court, prosecution witness number one, I don't know Wontumi from anywhere. I was never there when they discussed land reclamation and planting of coconut, let alone mining. And he says that I was engaged by PW2, and that anything done on the land has been at the instance of PW2. And that if we mine and got gold, the gold is for PW2. The money that was taken by the police is for PW2. The amenities that they retrieved from us is for PW2. You know, PW2 had earlier on given caution statement saying that I did not do any mining.
So for you, because going through the processes of the court, amongst many other things, there were questions raised when Justice Kokuvite was delivering a judgment, questioning the basis upon which, amongst many other things, where the second accused, for instance, Kwame Entry was, and the fact that PW1, for instance, and PW2 had alleged they were granted access to reclaim land and mine. The judge made a specific reference that that explanation by Wontumi was an afterthought, amongst many other things, and that based on circumstantial evidence, right? Based on circumstantial evidence.
An afterthought. Is the accusation that it was not an afterthought? After PW2 had given a caution saying that didn't do any such thing. Why was that one was not an afterthought? She in the position to say is an afterthought from another situation where there is an indication of an afterthought. Please, in all cases in criminal practice, that there is the benefit of that at beginning to go to the accused person, up to the judge. And we turn down our criminal jurisprudence. So I'm saying is that we will proceed on an appeal. And given the evidence on record, I will challenge it any time. That this evidence should not result.
Right. Mr. Apiakubi, have you spoken to Wontumi in the aftermath of this? Because you say you will proceed on appeal. Are you also returning as his counsel per the narration and the personal pronouns with which you're using?
You see, there's something that I have to share with you. This judgment was very out, and Wontumi knew what was happening before he went to the courtroom. He called me this morning and he told me he knew. So it happened this way. So he gave me even instructions that if it should happen this way, go on an appeal on my behalf. But it was people who told me that the country covered.
So officially he's asked you to appeal the decision of the court on his behalf, and that's what you're going to be doing.
That is exactly so. So I will compare with the person and see his position also, and see how we proceed going forward together. And we have to fight this decision on appeal.
So just quick one, right? Are you ready for the legal battle ahead? Because is he already being processed for prison as we speak? Have you been able to make contact with him as we speak at this particular point in time?
I haven't seen him, so I cannot say for a fact where he is. But having been caught, I think the next line of action will be for the prosecution to arrange incarceration. So he will be going through that. That notwithstanding, having taken instructions from him, compared with his counsel present, And then it means that we may have to start an appeal and apply for bail pending appeal, see how instructions will be.
Right. Just one final question. In the lead up to today, your side, because you're returning as his counsel, have been accused of deliberate using of the court structure to delay the entire process. Up until this point, even today, there was an application which was being moved to seek to refer the matter to the Supreme Court for interpretation. You've been accused of seeking to use legal gymnastics to delay the case in wait of a certain outcome at a national election. How do you respond to these claims even as you proceed going forward?
This case has not been the only case in Ghana. To other cases have been prosecuted. That what or not Wontumi State was exceptionally delayed, or whether or not Wontumi's case is of time. So this question will be moot if you make such references that there are people who will be put in the 8 years of period and stay in court for 8 years, and you will not make any submission to the fact that there were delays in those trials. You're talking about a trial that has gone on for one year, and you are saying that we have delayed in 9 months of a criminal trial of this nature. I don't want to respond. Question to yourself, you know that it is not relevant.
Right then. We appreciate you. I'm sure there'll be a bit more from you subsequently where we'll get a bit more in terms of reaction as well, because we know there are 2 other cases in which he continues to stand trial. One where there's a plea bargain. Pardon?
All we are saying is that if somebody commits an offense, let us prosecute him based on the evidence available. But you don't purport evidence and want to imprison somebody who is that I have done something that somebody instructed me to do, and that person becomes prosecution witness against a target who you want to imprison. It's a very dangerous precedent, and this is not Ghana that you hope to be part.
Absolutely. We appreciate you for speaking to us this afternoon. That's Andy Apiakubi. He will be counsel for Bernard Ntriboisiako when he begins processes to appeal this decision by the court. He's just told us that he spoke to him on phone and says that Wontumi said he anticipated this. And so...
if he didn't think about that outcome as well, which is why it would have been interesting to know from Andy how he prepared him for the possibility of going to prison as well, because this was a case that, on the outside, he could say was 50-50. He could have gone to prison or he could have gone home, as is with many cases, right?
Absolutely.
Because that's where, the balance is at the beginning of every case. And, to think that he... in the very last hours of the case, he said, I think I may go to prison. I wanted to know his mindset, coming to that point.
There's a bit more I'd wanted to ask him as well personally, because on the subject matter of no case, the judge in her ruling today touched on that subject matter again and reiterated, amongst other things, why there was a case for them to answer. Because you hear him speak to the fact that evidence has been concocted, amongst other things. Justice Kokuvite did not just read her judgment today. She actually went back to the arguments which were put before them that, look, the state had not they've not advanced an argument beyond reasonable doubt which suggests that Wontumi is guilty of these 2 charges. And she took time, went over it again, but we're being whispered.
And
continue to whisper in our ears.
I caught this in his last comments when he made that wild accusation against prosecution about concocting evidence. Right now, the trial has ended, the sentence has been given. We cannot talk about concocting evidence. we do not have anything to do with that. Just
Absolutely,
to clarify the
just
point.
Fair enough.
But over
Right?
the next few days of this week, maybe even into next week, it's going to be a very fascinating news cycle as the story develops. If you do not know Chairman Wontumi at this point, he's the man slapped in our background. Unfortunately, you're seeing just me, but there he is. He's headed for prison at this time.
At this time.
Because he's been sentenced to 2 20-year terms for his role in facilitating illegal mining without permit,
approval. Given approval. And just finally, it's a bit curious, right? So as it stands now, his legal representation, which is supposed to start the appeal process, who is Andy Appiah-Kubi, hasn't touched base with him. Yeah. His present counsel as well, it's outside of the jurisdiction. And so a bit of a difficult period. No,
which is why the question you asked about tact and strategy of delaying the outcome of the case is important.
Yeah,
right?
but he says it holds no water at all. And so, I mean, in the coming days, there'll be a bit more in terms of analysis and appreciation, right? Appreciation as well.
I can imagine that you law students will have a